Good morning, ladies and gentlemen, and welcome to CDH's Annual Employment Law Webinar. I'm Avinash Kavanji, and it's my great pleasure on behalf of Mr. Adil Patel and the entire employment law practice at CDH to welcome you to today's event. It's a thrill for us that so many of you have accepted our invitation to join. We look forward to sharing our insights on the next normal and the future of the employment relationship, and to reading your comments on our thinking. While this is understandably work in progress, given the global uncertainty caused by the present circumstances, we look forward to presenting our carefully thought through and debated analyses on issues that are likely to be crucial during the next 12 months and beyond. CDH prides itself on taking the lead and setting the trend on matters that are central to the world of work. One of the aims is to be able to guide the way in which employers will capacitate themselves to work within statutory and other constraints to steer the employment relationship in the future. Ideally, this will be for the benefit of the bottom line, employers, employees, and the economy. Fortunately, and despite all the uncertainty that abounds, predicting aspects of the next normal is not like gazing into a crystal ball and hoping that the desired outcome will be reached. It is possible through careful, measured analysis and knowledge management by a team of practitioners that are passionate about employment law and collaborate to understand the implications of recent case law and policy developments. We have a high-profile range of contributions to offer and hope that you will sit back and immerse yourself in the discussions to follow. Please make use of the open chat feature that this platform allows, and we hope to be able to respond to any questions posed, either in the chat feature itself or at the end of each session or during our panel discussions. Without further ado, it is my pleasure to introduce Mr. Cameron Selo Morajani, the Director of the Commission for Conciliation, Mediation and Arbitration, and our distinguished keynote speaker to you. Mr. Morajani holds the B Juris, LLB and LLM qualifications, as well as a diploma in ADR and PG Dip in corporate law. He is currently pursuing doctoral studies and is a professor of practice at the University of Johannesburg. Mr. Morajani has extensive private practice and trade union experience. He previously served as National Legal Coordinator for Nahawu before joining the CCMA as a commissioner in 2012. He was appointed as the National Senior Commissioner Legal Services in 2014 and rose to become the Director of the CCMA on 1 April 2016. The CCMA is the largest dispute resolution agency in the world. Mr. Morajani has served and led the organization with distinction, and he's also the recipient of a leadership award from the Law Society of South Africa. It's been my privilege to work with Mr. Morajani in various capacities during the past decade, including, most notably from my perspective, a high-profile case involving some soap opera stars that he asked me to try to conciliate in his presence. The less said about that unsuccessful attempt, the better. Mr. Morajani is unquestionably passionate about the CCMA and the quest for social justice. Welcome, Cameron. We look forward to your address on the efficacy and sustainability of remote hearings, the future of employment dispute resolution. I know there's going to be a lot of interest in what you have to say. I remind our audience to type any questions they may have for you in the chat feature. Thank you, Cameron.
Thank you very much, Avinash. Thank you so much. And thank you for the invitation. Let me just quickly upload my slides that I'll be using today. Just confirm to me if you can see them.
Yeah. Confirmed.
Thank you very much. I just want to make sure that what I have in front of me shows as well, so that I can start my presentation. Okay, I can see them on my side. Oh, there we go. So I've managed to say you can see my slides, right?
Yes, we can.
Yeah, my only issue, I need to see them as well, so that I can run them down. Sorry, I'm not able to see them on my side. Let me just close these. Yes, here we go. Thank you. All right. I'm good to go. I've already wasted you 2 minutes of the time. I want to thank Adil and the team. Thanks the program director, Avinash, our senior commissioner, the practitioner. Thank you very much for the wonderful introductions that you've made. I was quite excited when I saw the topic which was chosen for me to talk to, efficacy and sustainability of remote hearings. And we call it remote hearings, we call it online hearing, others call it virtual. It is debatable, not really badly, on whether we're talking remote or talking hearing. But what I'm happy about is that we're talking about the same thing. The bottom line is the same. In this presentation, I know I've got 15 minutes. I'm going to try to cover that as much as possible, because there's two components to this presentation. The one part, it has to do with the current state of affairs as things has been since the lockdown up to now, and the remote working and the remote hearings that we've been doing. And the second part of it has to do with the future of ADR. The future of ADR, my presumption is that it has to do with the future of ADR in the context of the presentation, because the subject of ADR itself on its future is quite a huge subject. I can say and have a disclaimer, Avinash, that I sometimes make these presentations, and some of well-researched presentations. I've had bad experiences where people take my presentation and write a paper about what I presented. At the time I'm trying to write, it's already published. So what I've done is I put very little meat on the slides, particularly on this subject, because the future of ADR, for me, it is exactly the nub of my LLD at the University of Johannesburg, the redesigning of ADR. So if I were to talk about the ADR future on its own, not in this context, as you can hear, it's a 3-year program. So, but I'll focus on the things that I think of practitioners is of great importance. There are certain direct suggestions and inputs that I will make in as far as that part is concerned. So as you can see, just as a start, in the period between March 2020 to 15 September 2021, we've had our online pre-conciliation. There's a process we call pre-conciliation. Sometimes people tend to confuse pre-conciliations with the conciliation itself. But the bottom line, they are all part of the family of conciliation. This is when we call parties over the telephone to seek their consent for us to resolve a matter over the phone without them attending to the session. We've been doing this before lockdown. So this is one great story that we have. So when lockdown happened, it just found us and we hit the ground running, because it was a process we're already doing. But we don't do this normally for the complex matters, like your domestic matters, for example, we call them Madam and Eve. And we do that for that purpose, and we are very successful there. The new feature which is seriously introduced by the lockdown is the online arbitrations. As you can see the numbers there, we are sitting at 2,184 up to 15 September, the current financial year. So it is, the take-up is increasing. The people were quite reluctant about it when it began. And I can say it outright as I start presenting that when it comes to online arbitrations, if anyone thinks that this is just the current, this is the future. This is how our arbitrations are going to run. You will see in the proposals that I'll be making. So in terms of our conciliation online, generally, we are sitting at 47,791. So we're making very good progress. And if you're participating in those proceedings, we're quite grateful, because we're really making serious progress. As I move closer to the nub of the presentation on the remote hearings, I can confirm to you, as you would see later in my slides, that when we're talking about the system that we use, we're using a hybrid system. Hybrid has two parts to it, as you can see on the slides. On the one side, you will see that we've got the online, which I will talk about quite more in the next slide. And the second part of it is the physical. So we call it hybrid, because you can have the online version and you can have the physical attendance to our offices. And there's other interesting developments that we've reached, and you may have read in the news. If you look on my slide there, particularly, let me just do a slide, yes. And as you can see there, SALGA is the South African Local Government Associations. I approached them to see if we can have an agreement that we can use their offices also where it is required, because they've got a better reach than the CCMA. And we, as part of that deal, I said, can you please ensure that there's also Wi-Fi? Because as we introduce this hybrid system, we should be able to use their offices. Some parties may be online, some parties may be at the offices. So we've reached that agreement, and we're going to be using all their main offices for purpose of hearings in cases where matters have to sit physically. So that extends our reach, and that increases our accessibility. The other approach which is affected by our budget is the CCMA offices having a free Wi-Fi. If we can have free Wi-Fi in all our offices, we can continue with our hybrid system. You can log in into Case While at the offices, and others can log in from outside. We can have both systems running, and that's what we're looking for. Into the physical, the one which is quite a bit of a problem that many of you practitioners are calling me about, it's the agreement that is reached by parties to use a particular venue. This one is important for me to explain just for 2 minutes. As part of the directives that you may have seen that I've issued, is that parties are encouraged to agree on a venue they want to use for the hearing, especially during lockdown. We have had a good success on this one. Parties will send us a letter and say, we've agreed to meet at the attorney's offices, the full hearing will take place there. All good. We supply support, we give you the CCMA case management officer, then they facilitate. We send you the link if there's others that needs to link outside that. So all of that is sorted. This one is a success story, and this is also the future of how we want to run our hearings in the future. This is the most important slides, which is the hub of the presentation. As I spoke about the hybrid system, but I want to focus on the online side of things, because that's the main thing. We've had goods and bads in this process. The first one, some of the complaints that we've got is that people get the link very late, or the CMO did not pitch up, or the commissioner can't connect. That is a problem that we have identified. So we've identified that there's an issue on the support system. But in the main, our CMOs or the case management officers have been very successful. In the future, when our systems is really advanced, the support system of the case management officer is going to become very critical in the development of our new online systems to make sure that the majority of our cases is online, because that's the approach we're taking. The second part, which has played a critical role, is the stability of the network. The network has to be stable. Really, it's not about data, it's about the stability of the network, because some of the cases get postponed because the network is not stable. In future, as we move towards the 4IR environment, but I tend to just limit on the online, we must have as a prerequisite, if this process were to be successful, a stable network. The third part, which is absolutely critical, and as attorneys or practitioners, you'll take serious a note on this one, the creation of a digital file. When we have time, we can talk more about the digital file, because this is about the formal documents. This is about, as you call them, the pleadings that the parties have, your statement of cases, your referrals are there, closing arguments are there, all of those things. We want to create a digital file. I'm doing one of the prime cases using a digital file system that we're trying to develop, but we will need assistance to make sure that happens. The venues of the parties, we encourage parties here, as I explained, in the hybrid system, while using online, that we can also use offices other than the CCMA offices. If we go full online, it means that we won't have walk-ins into our offices, but our society does not allow that, is the one that pushes us into a hybrid system. If we can have, as I spoke about, the stable online, that has no interruptions, that we use proper gadgets, that we have unlimited data, and a stable power, no load shedding, because some of the excuses, I wanted to share them with you, but I've got 5 minutes left, so I can't do that. But that issue of unlimited data and stable power is critical for us to succeed on online hearing or remote hearing. If we can't get that right, we will never succeed. If you look at the CCMA rules, you will note that almost every process that is there can actually be done online, each and every one of them. And I've picked a few examples. I won't take you through all of these because it's a lot. I won't make it in terms of time. For example, if there has to be any submissions of written arguments, whether it's a conclusion of the arbitration process or in limine processes under the category of in limines, you can do that online. We don't have to come to offices because it's a simple process. The condonation applications, you will note that in terms of our rules, Rule 9 and Rule 35 deals with the condonation principles and requirements. That can be done online. Although sometimes the problem when it comes to condonation because people tend to, leave out critical information. I can just quickly give you a good example of one case where an employee was like 40 days out of time on condonation. And then on one day, then she pitched up and then we sat it down, sat there, said, can you explain how you cover the 40 days that is missing? And in the process, inadvertently mentioned that actually there was an appeal that she lodged internally. So then when you looked at the period in the appeal, it wiped out the entire condonation. There was no need for condonation. So there's certain exceptions in some of these eliminated processes that we online, but we're strongly encouraged to do so. On collective bargaining, Section 150 intervention, there's very good examples I can use, but because of time, I can't get to them. Just to show you that when it comes to online hearing, remote hearings, the future is bright. The rest I will not spend time on. There are pros and cons on these. Of course, they're listed there. I won't take you through them. But one of the greatest things is that we will be able to have, and we have had, hearings that ordinarily would be postponed, but they continue until late because people are sitting comfortably at home or in offices. We're able to conclude cases using online. But I won't take you through all the list because I'm left with only 2 minutes. And those are the cons that comes with it. I think I've spoken to those cons there. Let's look at the future of ADR. There's an interesting concept in the research. I've given you the reference there. There's a lot more involved in this than what you see on the slide. But there's something called the fourth party. They call it the fourth party because the parties that are there, not party in the real sense as we know them in the referral. The applicant, the respondent, the mediator, and technology. But I introduce what I call the fifth party, the interpreters. Because without an interpreter in certain cases, the case will collapse. But the online or remote approach has created the fourth party. But we'll discuss that concept when you have time, because I've now run out of time. Some of the areas of improvement, for example, without going into all of those, the automated Rule 20. If you look at the Rule 20 content in terms of the pre-arbitration that we set down, if you look at the content of that, most of those things can be done in an automated way. Or if we use some form of a blend between automation and artificial intelligence, we can get rid of a number of things instead of setting it down and wasting a lot of time in terms of the pre-arbitration hearing. As a commissioner and as a practitioner, if there's anything I don't falter on, is to do a pre-arbitration. It makes my hearings very interesting and very short, and I know exactly what I should decide, and the matter proceeds with efficiency. The future options as part of our ADR concept generally, not necessarily on employment law. We've got those three critical options. The first one is the full IT, the full ICT. The full ICT means that there's no walk-ins, everything is exclusively online. There's a number of things here in terms of commercial disputes and e-commerce disputes where they use the full ICT system, which is very effective for them. But for us in our environment, and in terms of our, it's not going to be realistic. My time is up. The second option, which deals with what I just mentioned about the initial stages and all of that, that's the second option. And the third option is what we're currently using, which is a hybrid system. So these are I can't talk to that now because I've run out of time, but I think at some point we'll talk about that, about the other aspects of the future itself. Avinash, I've promised you that I will finish on time. It's a well-researched subject. I tried to do it as quickly as possible, but I hope it gives some sense to the parties on where we are, where we're going, and what the attitude is, because our future, as matters stand now, the way we want to have it, it is indeed a very hybrid system, because the unequal nature and inequity in our society, especially the human factor part of social justice, we cannot go full online because the society, because of those inequalities, does not allow it. But the greater part of what we're going to do will largely be on the online side of things, and that is the future, and that future has already started. Thank you very much.
Thanks very much, Cameron. I'm really interested to hear about you referring to technology as the fourth party, and it has certainly stimulated some questions in the chat. The one theme that is coming through relates to one party being reluctant to take the plunge and go online and insisting on a physical hearing, and just your take on whether commissioners should continue to insist that both parties consent.
You see, that part, it has landed on my desk. I've received a lot of complaints that some of the discretions exercised by our commissioners is not a very judicious one. It's also not very considerate of circumstances. We are in a pandemic, and other than the issue of pandemic, the convenience that comes with certain processes, as you may have seen in my presentation, there are certain processes really you don't need to be physical. In some cases I've seen where parties are really made, because at the end the commissioner has to make a call on whether we go online or not. But there are some decisions which I don't agree with, where matters should have gone purely online. And I've intervened in cases where parties have asked me to intervene and ask, why are we going physical when this can be done completely online? Sometimes it's the late communication of that, because sometimes if the hearing is tomorrow and by today you don't have the link, and witnesses have to travel. Some are outside the province. In some cases, we've had witnesses who are overseas, not even local. So I do not encourage it. And I'm going to work on that issue to make sure that we become very practical and reasonable in our exercise of discretion to make parties to come to our offices. But priority one is making sure that if it can be done online, let's do it online and keep it like that.
Thanks for that. I think it's your remarks have impressed on how important it is to get the broader infrastructure in place for not only tribunals like the CCMA, but for courts to now take the next step. Of course, what the CCMA manages to achieve in terms of digital bundles and the like is also going to be very, very important for the high courts and the magistrates courts going forward. So the stakes are quite high. Perhaps just your final remarks on that and getting the right infrastructure.
Firstly, as I talk to you as practitioners, and I'm going to be on a serious economic campaign, asking for support, pledges, and donations for us to build our infrastructure. If this future is to happen, because we don't have a choice here, the efficiency of this is unquestionable, right? We are going to go into that campaign personally to say, can you donate for us to have a proper infrastructure? That is completely indispensable. Let me state one important aspect, Avinash, that you will relate with very well and the practitioners would. In my slides, because of time, I didn't talk to it. You see, the system that we're using now, like we are using now, the MS Teams, the recordings of these proceedings are held in the cloud, and they're not even located in South Africa, right? There were some other jurisdictional issues and people were raising which were not necessary, but the entire record, as you know that when you bring Section 145, you're going to need the record that you must file with the court and with the parties and the portions of the record that you're going to need for the purpose of your proceedings. What has happened, which is part of my doctoral studies, is that the review process as we have it will change that landscape, because it's no longer just about the audio that we are talking about. We are now talking about the video component of that. So when you say, I'm going to file the record, which part of the record are you filing? And if you're filing both, what is then the role of the court in the review process, knowing that it is a motion proceeding? What are you going to do with the visual part of the record? Will the Labour Court, in its review of the conduct of the commissioner, because Section 145 talks about a defect in the award, some of the allegations that are made against commissioners, you need to observe certain things. Will the Labour Court, the Labour Appeal Court, and the Constitutional Court take interest in the other component of the report when you're talking about Section 158 or Section 145 in terms of the reviews? That, to me, has become an interesting question, together with the impact of language and everything else that comes with that, which we can talk about later. But in as far as the record is concerned, the record has become a significant part. That's why I was talking about the digital file as well, because what you transfer from the CCMA as a record that you take to the Labour Court, if we are dealing with the digital file, it means we no longer also deliver the traditional file, we're delivering a digital file. But if the infrastructure between the CCMA, Labour Code, LSE, and Concord is not in all fours, it means you find a disjuncture when you're talking about record. We may file a record that the court may not be able to use, or we may over-comply with the record that they want to use. So it does bring a very serious transformative component of how we look at records and the importance of infrastructure and the reviews and all.
Yes, well, we look forward to seeing your published work and your doctoral thesis on exploring some of this in greater depth, Cameron. I think that would be a really useful contribution. On your last point, of course, in terms of whether the courts will consider the full record, including the video footage, one will have to tell and warn some of the older school judges that it's no longer going to be possible for them to gaze into the distance with their eyes closed. But I'm sure that training can happen. We want to thank you for the thought-provoking address that really sets the tone beautifully for what is to follow. We also appreciate your willingness to have fielded these questions and your office's undertaking as well to respond to any questions or comments that we may not have addressed due to time constraints. I see there are some questions about the general operations of the CCMA that have come through. We want to wish you and your team well in dealing with all the challenges that people in your position encounter, and indeed with your campaign to raise the type of funding that's going to enable the technology that we require in order to press forward. So thank you very much for taking your time to share so much with all of us today.
Thank you very much for having me. Thank you very much. We did promise that we will answer the questions that you're going to send to us that may have been sent by the participants, and we will respond to all of them.
Thanks very, very much.
Thank you very much, Avinash.
It's now my privilege to introduce Mr. Adil Patel to you. Adil is well known as the head of CDH's employment law practice. He's the quintessential thought leader, combining his in-depth expertise in employment law with an insatiable energy and drive to lead the practice and firm into its own next normal. Adil has worked across multiple jurisdictions in Africa and globally, and has a first-class record in representing a number of state-owned enterprises and listed companies. He's also acted as a judge of the Labour Court on a number of occasions and has been recognized in top bands by various international rankings agencies. It's always a pleasure listening to Adil's fresh thinking and clear delivery. Adil, over to you.
Thank you, Avinash. Before we kick off, we start off with a video. Thank you. Thank you. So welcome to our 10th annual Labour Law Conference. Let's have a look at a video from the World Economic Forum. Thank you. Hosting a webinar, producing a case law booklet, developing videos and marketing material all remotely is not feasible without significant input from various operational and legal professional support, namely marketing, KM and professional legal support. During these challenging times, these internal services are essential to our continued ability to remain functional and produce the kind of services and value add that our clients have come to expect from us. These jobs, although adapted, will remain relevant. They are required to deliver any professional service, as indicated by our esteemed director of the CCMA. Traditional ways of engaging with our clients and means for enhancing our client service experience and engagement with our firm are gone, potentially forever. While for lawyers, the dispensing of technical legal advice before and after COVID remains much the same, the ways in which we have had to adjust How we do this has required these operational areas to step up, adapt, and repurpose themselves quickly in order that our lawyers remain effective at their core service and deliverables. So how has CDH's Africa-wide employment team ensured that we remain relevant to you, despite not having an opportunity of sharing a cappuccino, Americano, a latte, or a chai latte when engaging in face-to-face presentations with us, as we did before? How have we tried to remain front of mind and relevant to you as a service provider when all we have had at our disposal for most part was a face on a video chat? For one, we rapidly adopted and then entrenched a future-fit mindset, interrogating global employment-related trends and what these might mean for our clients and their specific environment context, seeking to understand their potential implications for you across Africa. In parallel, we closely followed our country's challenges in seeking to fight and contain COVID with its inevitable missteps and the consequences thereof for both lives and livelihoods. And to be entirely frank, your sustainability as our client so that we could configure solutions that showed up your ability to remain viable and functional, while at the same time provide solutions that protected your employees, their health and their jobs. We were there providing you with critical and timeous thought leadership to assist you in making business decisions that had implications for yourselves, your employees, the communities from which they come, or in which you have operations in South Africa and at large. Our CDH's new normal has grown into far more proactive engagement with you regarding your needs on what keeps you up at night. We sincerely hope that you have noticed an office, a physical structure, is no longer as foundational as it was previously. CDH's team of employment law experts are truly global citizens hailing from across the world, including India, the UK, Switzerland, and Kenya, apart from South Africa. These experts contribute a rich diversity of views, and we continue to mine for best practice in service of our clients. Empowering our clients with knowledge and training remains, in respect of our discipline, that is in turn a key component of effectively managing your business. The key calling card of our employment law team. Innovative ways have been adopted to ensure that we deliver continuous legal education to our clients by developing e-learning tools, coding agreements, and adopting some artificial intelligence tools. The pandemic has come at a very high and tragic cost for many, if not all of us. My hope is that we will continue to do whatever we can to fight this virus and to emerge stronger, better, and smarter for the sake of all of us. Please take care. Our hope is that you will find our webinar and case booklet, which will be emailed at the end of the day, interesting, thought-provoking, and most importantly, as a means to empower you to engage with our new normal. Thank you for joining us. I now hand over to Imran Mohammed, a director in our department, who will moderate a discussion on compliance with BEE and the Employment Equity Act. Thank you and keep safe.
Thank you, Adil. Good morning, everyone. Outside the proposed changes to the property rights clause in the Constitution, and that's very well known as the amendments to Section 23, which allows for expropriation of property without compensation. The most controversial pieces of legislation in the workplace since 1994 have no doubt been the Employment Equity Act and the Broad-Based Black Economic Empowerment Act. Unfortunately for me this morning, I need only to moderate this controversy because my employment law co-director, Heda Shenzima, is going to delve into the issues relating to the Employment Equity Amendment Act, and my corporate law director, co-director, Varushka Pillay, will do likewise. What we want to explore with you this morning is a question relating to whether or not there is in fact an interplay between the two pieces of legislation. And this, in reality, is not an academic question. Both pieces of legislation have a transformative and economic empowerment agenda as a start. The elements in the BEE codes, for instance, have two issues which probably have areas of common terrain relating to employment equity and the BEE legislation. One is skills development and the other is management control. There's significant amendments being proposed to the Employment Equity Act, and we're beginning to see an increase in litigation in the workplace by employees who are relying upon the BEE legislation in order to assert claims in the workplace as employees. But more about that later. Let's get into a discussion with Varushka, firstly in respect of the BEE legislation. So Varushka, if we can start out the conversation perhaps, looking at both the BEE Act and employment equity, both we appreciate are grounded in the right to equality. Both seek to eliminate unfair discrimination and promote greater diversity and inclusivity within the broader economy. On the back of that, should employers approach employment equity and BEE as separate and distinct components in their approach in business?
Imran, thanks. I think ideally these aspects should be considered together. Just to explain from a BEE perspective, in terms of the BEE codes or any applicable sector code, there will be an element known as management control, which seeks to assess the extent to which a company employs Black people within all levels of management in that company, both on gender as well as racial lines within the context of the definition of Black people. B, compliance is also measured on an annual basis, and if a company achieves the targets in the codes, then it also achieves a higher score for management control. Given that the Employment Equity Act requires an employer to also submit or devise an annual employment equity plan for the improvement in the representation of designated groups, it makes sense for those planning a company's employment equity plan to actually work together with those that are working on the improvement of its scorecard.
So on the back of that, I mean, it almost, you perhaps have already preempted the answer to another question that I wanted to ask you, which relates to the level of interaction between, let's call them HR executives within a channel in business and transformation executives. You'll know a number of businesses have transformation officers or transformation executives. What level of interaction do you think there should be between those different channels in business?
Again, I think that there should be regular ongoing interaction. Firstly, in regards to the planning phase of matters, to make sure that your employment equity plan is aligned with your planning for your BEE scorecard achievement. And then there should also be an ongoing engagement to determine whether or not the actual targets and plans are being achieved. I think that just lends itself to greater possibilities of transformation within the organization over a long term.
So talking about that, perhaps let's pivot, Varushka, to a question relating to the Employment Equity Act. The Employment Equity Amendment Bill has been in the making for a while now. Just talk us through what is the status of the bill at present, and perhaps just at a very high level, what are the main proposed amendments employers should be alive to?
Thanks, Imran. The current status of the bill is that the Department of Employment and Labour's Employment Equity Directorate is gearing itself for the implementation and enforcement of the new Employment Equity Act once the parliamentary process is to be finalised in March 2022. The bill currently is expected to go to the National Council for Provinces for consideration very soon. We're not exactly sure as to when, but it seems in the press and the alerts that we've been receiving that it's imminent. Further sector engagements, which already commenced, as we know, in 2019 on sector targets, will continue. And to date, these engagements have already been held in the mining, the financial and business services, wholesale and retail and construction sectors. At this stage, it would seem that the Department of Employment is currently busy analysing written submissions that it has received from the remaining 17 sectors, and they've reported that it is envisaged that these will be concluded by February 22. In terms of what is proposed, I'm just dealing with the high-level amendments, which we've notified as being the most notable. The first one being is the change to the definition of a designated employer. This means that employers who employ fewer than 50 employees, regardless of their turnover, will no longer fall within the definition of a designated employer. The impact of this means that many employers, especially our small to micro and medium enterprises, will not be required to comply with certain provisions of the Act. But however, notwithstanding that, however, the employment equity reporting will remain. Another notable change is the sector-specific numerical targets introduction. This is the introduction of a provision which will empower the Minister of Employment and Labour to determine sectoral numerical targets. I'll get into further detail later when we talk.
You mean the controversy around that, Hera?
Yes, we'll deal with that. There's a lot going on in relation to that. And then significantly is the reclassification of people with disabilities. The definition of people with disabilities is going to be amended in line with the definition in the UN Convention on the Rights of Persons with Disabilities, which will now then include persons who have a long-term or recurring physical, mental, intellectual or sensory impairment, which in the interaction with various barriers may substantially limit their prospects of entry into or advancement in employment. Another interesting aspect will be the removal of the need to do psychological testing. And of significance to us, obviously, is the trade unions and consultation proposals, where a workplace has a representative trade union representing its employees. The employer will be required going forward to consult with the trade union only and not its employees anymore. So there'll be quite a significant impact in relation to the workplace and the interactions that are happening there. So that is a high level changes that are being proposed at this stage. Thank you.
So that's quite intriguing, Hera. I mean, three things obviously stand out. The numerical targets, and there's been a fair bit of controversy around that. The second is the let's call it the reclassification of what is a designated employer. That's very important. And a consultative party being a trade union and not employee representatives. So that's quite significant. Well, let's hope these amendments are not going to be like the POPIA amendments in the making for 10 years, and we'll continue to talk about it year after year.
Sure. I mean, everything that we've been reading and the alerts that are coming out, Imran, it seems that there is quite a heavy drive now that this has to come through, in the sense that the previous attempts at making sure that transformation is effective and is working is not working, and it's for this very reason that there seems to be quite a hard drive to get this bill through.
Fair enough. And Hera, because there's two labour lawyers on this panel, and because everybody who's not a labour lawyer says labour lawyers don't practice law, I'm going to ask a very difficult question of Varushka. Varushka, is there a possibility for an employee who alleges discrimination in the workplace to also claim that the employer's conduct constitutes some form of fronting under the BE legislation?
Imran, yeah,
difficult
yes. I think there certainly is that possibility. Fronting is a very broad term in terms of the BBBE Act. It is any initiative or act or conduct that has the effect of directly or indirectly undermining or frustrating the objectives of the BE Act. Those objectives include increasing the participation of Black people in the South African economy, as well as achieving a substantial change in the racial composition of ownership and management structures, and within skilled occupations. So if, for example, an employee has been made a participant in an employee share ownership scheme or been given certain senior roles but can demonstrate that those arrangements were really just made on paper and have been designed to undermine or frustrate the objectives of the BE Act, then certainly there would be a risk that they could allege fronting practices.
And on perhaps on the same track, how are fronting complaints made, number one, and how are they adjudicated?
Okay. Typically, a fronting complaint can be made to the BBBE Commission. There is a form that needs to be completed together with detail of the alleged fronting practice, and that is submitted to the BE Commission. The Commission will then look into whether or not there is a possibility that the alleged conduct has occurred. They will conduct an investigation in terms of the regulations. They have a period of 12 months to complete an investigation. And they generally engage directly with the party who's been accused of the fronting practice, notify them that the complaint has been made, and make inquiries of them.
Right. We'll perhaps return back to this concept of fronting a little later. Head back to the controversy on the questions relating to the sector-specific numerical targets. Just talk us through that proposal a little more, just unpack it.
Sure, thanks, Imran. So the aim behind the introduction of the sectoral targets is to force employers in specific sectors to look at affirmative action. Because as a designated employer that wishes to engage in government tenders, and that's the important aspect of it, you will only be considered if your organization meets the sectoral objectives set by the Minister of Employment and Labour. Employers and companies will then have to meet a set of conditions before being issued with the Employment Equity Compliance Certificate as a prerequisite for access to contracts with state and any of its organs, and that this certificate will only be applicable or will expire after a period of 1 year from the date of issue. Therefore, in terms of the proposal, and this is where the controversy comes in, is that the Minister may identify national economic sectors, and after consulting the National Minimum Wage Commission for the purposes of ensuring the equitable representation of suitably qualified people from the designated groups at all occupational levels, set numerical targets for any national economic sector. These targets may differ across occupational levels, subsectors, regions, or based on other relevant factors. If this provision comes into force, this will give rise to a significant change. To date, as we know, designated employers, when determining numerical goals, frequently have regard to the demographic profile of the economically active population. The amendment, if effected, will require that an employer, in setting its numerical goals, comply with any sector target which the Minister may have determined and which applies to the employer. So that's where the issues are arising. The emphasis, obviously, from the department is that we're consulting with you, we're listening to you, we're hearing what you're saying. Obviously, the invoice or the concern from the other side as well, if we don't reach consensus, well, then how is it going to proceed after that? So there seems to be huge debate between business and government in relation to how this is going to be implemented and whether it's going to actually be a joint consensus seeking process as we know is set out in the LRA, or is it going to get to a point simply where the Minister says, well, we've consulted and this is what we are going to be implementing in terms of the numerical targets.
So on the chat here, there's an interesting question. You're just going to have to bear with me. I'm trying to download it on the side.
If you could just read it, I don't see it. Thanks, Imran.
Matthew Stevens asks an interesting question, and I've now got a pop-up on my thing that tells me something about Signature Manage Outlook Edition. Let me get past that. This is the wonders of the new normal. The question from Matthew Stevens is, do we expect sectoral targets to be phased in over a period? What's your reading around that?
Well, my reading on it, as I'd said already in my intro to you, is that the consultation process has been finalized with the sectors that I had mentioned, and that it is envisaged by February that the remaining 17 will be concluded. So time will tell whether or not those timeframes will actually be adhered to or not. And in terms of the phasing out, the plan is obviously a 5-year target, and that by September 22, the current employment equity plan that your business has will then be phased out, and then you have to introduce the 5-year target plan, if I can call it that, going forward.
So I mean the amendments in relation to reporting and how to give effect to new plans is going to change significantly from what we have currently.
Absolutely.
That's no doubt.
Absolutely.
Okay. Then Varushka, there's also an interesting question from an unknown participant who asks, what is the consequence of fronting to the employer?
Sure. So I think importantly, once the BEE Commission has completed its investigation and it makes a finding, it has an obligation in terms of the Act, to the extent that it finds that there has been a fronting practice, to report that to the police services and the NPA for further investigation and potential criminal prosecution. The fronting practice is a criminal offence, and an individual may be imprisoned or fined. Importantly, a company that's been found to have committed fronting practice could be liable for a fine equivalent to up to 10% of turnover.
And have you in the course of your practice come across a fair bit of fronting complaints to the BEE Commission?
Yes, we have. We regularly assist clients with these matters. We've seen several fronting practices being investigated by the Commission. They're very active in this regard.
And do you find some of them emanating from within the workplace, or from perhaps shareholders or directors, or where do you find it?
Absolutely. We've seen complaints emanating from employees, in addition to shareholders, potentially competitors, and the like. And the example that I used earlier of an employee share ownership scheme is in fact a real life experience that we had, where an employee did report their employer to the Commission for a fronting practice.
Perhaps Varushka, just unpack the concept of in your parlance called ESOPs to the audience, so that perhaps it's just a better understanding around the concept.
Sure. They can take several forms, but the most common is where a trust is established, in terms of which a certain class of employees are made the beneficiaries of that trust, and the trust itself becomes a shareholder in the employer. And over time, the employees have the ability as beneficiaries of that trust to benefit through dividend flow in respect of the shares that the trust holds, and potentially also in relation to the disposal of their participation rights in that trust.
Okay, and moving away from ESOPs into, let's call them multinationals. It often happens, the setup of a multinational in South Africa, one of the issues that arises during the course of that setup discussion is BEE compliance. How does a foreign-owned company deal with BEE compliance?
In the same way that South African registered companies do, the challenge with foreign-owned companies generally tends to be around ownership. In our experience, multinationals become quickly aware of the pressures to be BEE compliant within the economy, and do well in respect of all of the other elements, and then ownership is the one where there is always a challenge. And we do see that there tends to be favoring of structures such as employee share schemes and broad-based, sort of community-based ownership schemes for their benefit.
This topic fascinates me because, I mean, we run into it. In fact, we're running into it more often than not these days as employment lawyers. To what extent do you see trade union activism around BEE compliance?
So it's interesting because it's been fairly recent. I think we've had commonly several CDH clients who've received letters from trade unions requesting information in respect of their BEE scorecards and the information that's been input into determining what their BEE score is. That's been a fairly recent development. I have not had much of that in my space up until now.
I see the good professor has appeared on our screen, and I don't mean the money heist, Avinash. So we're going to conclude simply by handing back to the good professor. Avinash, we'll hand back to you. Hedda, Varushka, sorry, there's lots to talk about. We just haven't had enough time. But
thank you, man. Thank you, Varushka.
Thank you very much.
Thanks.
Thanks very much, Imran, Varushka, and Hedda for wrapping that up for us. There may be a couple of questions. The topic generated quite a lot of interest, so I know that you'll take some time to respond to that on the chat. The next session focuses on retrenchments, business rescue, and mandatory vaccinations. I'm particularly interested in hearing the presenters reflect on cases that have considered issues such as business rescue and severance pay, and whether business rescue renders retrenchments a fait accompli. And then to the hot topic around the management of objections and exemptions to mandatory vaccinations, whether an employer may dismiss an employee that refuses to vaccinate. I think that's the big question at the moment. So I invite Jose, George, Toby Jordan, and Desmond Odihambo to address these issues, and remind you all to continue to pose any questions you may have in the chat feature. Thank you.
Good morning, Professor. I see that Jose is stuck. I don't mind kicking off the presentation.
Thanks very much, Toby. Please proceed.
No problem. Let me share my slides. Almost there. So while I look for my slides, my name is Toby Jordan. I am a director in our dispute resolution department, and I head up the firm's business rescue, restructuring, and insolvency sector. Let me just see. My slides are loading. So give it a moment. You can almost see it on my side. There we go. Okay. So as a business rescue lawyer, I'm grateful for the opportunity to present today, as I believe that the devastating effects that COVID-19 has had on industries all over the world, and in particular South Africa, has fast-tracked the need for many legal disciplines to overlap. We have seen this quite obviously in the employment and business rescue legal space, where many companies have had to contemplate retrenching their employees while faced with a business rescue process. I see my slides have been stopped. Let me just see if I can share it again. Sorry for that. There we go. Okay, it's coming up. The business rescue proceedings are aimed at rescuing a company which is in financial distress by allowing it to reorganize and restructure its affairs, assets, equity, debts, property, and liabilities. The employees of a company are defined as affected persons in terms of Section 128 of the Companies Act, and are therefore afforded certain rights in a business rescue process. So these rights include the right to be represented by a trade union. An employee has a preferred unsecured claim against the company for any remuneration, reimbursement for expenses, or any other amounts relating to their employment. An employee is also entitled to receive notice of each court proceeding, as well as meetings pertaining to the business rescue process. An employee is entitled to participate in court proceedings and meetings, and they are also entitled to consult with the business rescue practitioner in drafting the terms of the business rescue plan. And one must then also further consider the special protections afforded to employees in terms of Section 136 of the Companies Act. This section provides that during business rescue proceedings, employees who were employed before the commencement of the business rescue will continue to be employed on the same terms and conditions, but subject to changes occurring in the ordinary course of attrition, or the employees in the company agreeing different terms, which complies with the applicable labor laws. So therefore, it's clear that during business rescue, employees are afforded exactly the same rights in terms of the LRA and BCEA, which includes the right to a fair dismissal. So if we go over to our second slide, then we will look at the role of the business rescue practitioner then in the retrenchment process. So in considering the BRP's role, which commences or is in a retrenchment process, which commences or is contemplated during the business rescue, we need to turn to consider the most recent landmark judgment of the Labour Appeal Court in the matter of SAA versus NUMSA. So in this matter, the Labour Appeal Court considered whether retrenchment of employees for operational requirements during business rescue was permissible in the absence of a business rescue plan contemplating such retrenchment. And the court found that in terms of the Companies Act, it's clear that a business rescue plan must be finalized and adopted before embarking on the retrenchment. The court highlighted the need to protect the rights of the employees in terms of Section 136 of the Companies Act, which, as mentioned, obliges the practitioner to ensure that the employees continue to be employed on the same terms and conditions, except where a change in terms and conditions were agreed to by the employees or by way of attrition. So previously, a practitioner would have been able to immediately commence with certain workforce restructuring measures. However, and as a result of the SAA case, if the practitioner contemplates that a retrenchment process may be necessary, they may only embark on it once it has been contemplated and provided for in the business rescue plan. And it's the duty of the practitioner to draw up a business rescue plan, which must be published within 25 business days after the date upon which the practitioner was appointed, or any such longer date as may be allowed by the creditors or by the court through an application. So accordingly, in terms of the SAA judgment, a company under rescue can only commence the retrenchment process once it has been provided for in an adopted business rescue plan. So this then means that any notice of retrenchments in terms of sections 189 or 189A of the LRA will only be distributed roughly and at the earliest to the employees after about the first month of the rescue proceedings, albeit considered or contemplated by the practitioner already at an earlier stage. And therefore one could argue that the contemplation of retrenchments would be a fait accompli, as the employees would only be notified of such contemplation after the business rescue plan has been adopted, thereby potentially causing an immediate breach of the requirements for a fair retrenchment process in terms of the LRA. So once the business rescue plan has then been adopted, with terms contemplating the retrenchment, the practitioner will take the role of the employer in a retrenchment process by ensuring that the provisions of Section 189 and 189A, as well as any other relevant labour law legislation, as well as those in the Companies Act, govern the rights of employees in a business rescue process. But from a practical perspective, the main problem that the SAA judgment caused is that in many rescues, and purely from a commercial perspective, it is sometimes vital for practitioners to immediately embark on the retrenchment process. However, they must now wait for the plan to first be adopted, and even though our Companies Act prescribes that the plan must be published within 25 business days, we often see in practice that this cannot be achieved. So to fix this conundrum, we suggest to the practitioners that we represent to conclude voluntary severance packages with the employees, or alternatively, when we advise companies considering filing for business rescue, to commence the restructuring process prior to the commencement of the business rescue proceedings. And because retrenchments are now to be contemplated in a business rescue plan before the practitioner can commence with any kind of retrenchment process, such severance pay packages should also be contemplated and included as part of a business rescue plan. And must also be borne in mind that the obligation to pay severance is a statutory obligation which arises under Section 41(1) of the Basic Conditions of Employment Act, and is therefore a debt owed by the company under rescue to its employees, which is treated in the same way as debts which are owed by it to its other creditors. Now, Section 135 of our Companies Act provides that any unpaid amount of remuneration, reimbursement for expenses, or any other amount relating to employment that becomes due and payable by the company during its business rescue proceedings will be regarded as post-commencement finance, or commonly referred to as PCF. And accordingly, any severance payments which becomes due and payable by the company as a result of a retrenchment concluded during its business rescue process will be treated as PCF, and it will be an amount relating to employment that becomes due and payable by the company during its business rescue proceedings. Now, the practical consequence of such classification is that severance payments are conferred with a preference in the payment waterfall of creditors. In other words, after the payment of expenses incurred and remuneration earned by the business rescue practitioner, the payment of employees' claim to severance will rank in priority to the payment of any pre-commencement creditors of the rescue process. And claims to severance amounts are therefore statutorily required to be paid before the general body of unsecured creditors. So what this means is that if there is not even sufficient cash to satisfy employees' claims to severance payments, then the general body of creditors won't receive anything by way of a dividend as a result of the business rescue process. And if this is the case, it would also mean that the company would be disqualified from being placed under business rescue, as there wouldn't be a reasonable prospect of it being rescued in law. Business rescue practitioners should accordingly be alive to these risks and ensure that there are sufficient funds to pay, firstly, the employees' claims to severance payments, and secondly, a dividend to the general concurrent creditors, which is greater than which they would otherwise have received during a liquidation. And if the company does not have sufficient funds to settle these claims, then the business rescue practitioner would be unable to conclude that there is a reasonable prospect of rescuing the company, and the company will be precluded from being placed under business rescue. That then concludes my presentation on the interplay between business rescue and employment. Happy, Jose, I see you up. Happy for you to hand back to you then.
Thanks, Toby. I think we need to call Cameron back. Maybe he can help me with my technical problems. Good morning, everyone. You can see from that slide, I'm going to be talking about mandatory vaccinations. We've seen in the media that two large employers recently, Discovery and Sanlam, have decided to implement mandatory vaccinations. We're also seeing a number of our clients who do intend implementing mandatory vaccination. So it's fair to say that it's somewhat of a hot topic at the moment. Just find the right slide. Oops. Okay, so what I'm going to be looking at is the consolidated directions. Okay, these are published on 11 June this year, so quite recent. It's clear from the title, it's a consolidation of previous directions, but what makes this one a game changer is that it now allows employers to introduce mandatory vaccinations for their employees. I'm going to look at the direction, but I'm going to focus only on those aspects that relate to mandatory vaccinations. And I think this will set the groundwork for any questions that you have in the Q&A session. So, okay, what do you have to do, right? As an employer, the first thing you have to do is conduct a risk assessment. Now, there's nothing new about that. You had to do a risk assessment before COVID, and you should have also updated your risk assessment when the first directions came out in April 2020. However, now what you're required to do is look at your operational requirements, okay, of your workplace and decide if you're going to make vaccinations mandatory. So, for example, if you operate in healthcare, okay, that's a high-risk environment. You're dealing directly with sick people. You in an environment where you can't social distance 1.5 meters, etc. There, it's probably something you seriously want to consider. Okay, retail, it's relatively high risk. It's customer facing, lots of customers walking through a store, passing through the checkpoints, etc. It's maybe something you also want to consider. If you, like us, and you're office bound, it's relatively easy to isolate at work. You don't have to deal with very many people. You can do things virtually. Mandatory vaccination may not be that important. Okay, so that's what I mean by the operational requirements of the business. If you do intend implementing mandatory vaccinations, you need to do a risk assessment. Okay, and that involves two categories basically. Identify those employees who, because of the work that they do, are at a higher risk of COVID transmission. So I mentioned the healthcare sector, and they must be vaccinated, obviously, or people who, because of their age or comorbidities, are at a greater risk of severe illness or death if they contract COVID-19. So we've already introduced that category. Those are the vulnerable employees, and we've covered them in previous directives as well. So now you've done your risk assessment. Okay, what do you have to do? You have to either develop a plan or amend your existing workplace plan. Okay, and you've got to outline the measures that you intend implementing in respect of vaccinations. You must consult about the risk assessment and the plan. Again, who you do consult with? You consult with a representative trade union and the Health and Safety Committee. And if there's no Health and Safety Committee because you don't have the numbers, you'll consult with the Health and Safety rep. Then you finalize your plan and you make it available for inspection. Okay, who inspects it? The Department of Labour. It's also available to the Health and Safety Committee, obviously. So there's a long list of things that must be included in the plan. These are all set out in the directions, so I'm not going to go through all of that. But for our purposes, obviously identify the employees who are at risk, and then obviously state whether you are going to implement mandatory vaccinations. So importantly, and this is where a lot of the debate is happening, okay, when you develop your plan, you need to take into account the rights of employees to bodily integrity and the right to freedom of religion, belief, and opinion. Okay, and this basically opens up the objection space, which we'll talk about a bit later. Just want to go to my next slide. The direction also places a number of administrative measures on employers. For our purposes, for vaccinations, if you employ more than 50 employees, you must submit a copy of the assessment and the plan to the Health and Safety Committee. You must have your employees disclose whether they have comorbidities, so you ask them. And if they do, you have to implement special measures to accommodate them. Like I said, we've already got this from previous directions. Interestingly now, you have to, well, I guess it's not interesting, it's actually quite obvious, provide your employees with information relating to COVID-19. So the directive says preferably, if you can, do it in the form of notices and leaflets. So what do you inform them about? The dangers of COVID-19, how is it transmitted, how do you prevent it, etc. And then also the nature of the vaccines that are used in South Africa, and what are the benefits of the vaccines, what are the contraindications, and what are the risks of side effects. What else you have to do is assist employees to register on the EVAC system. That's the electronic vaccine data system, and give employees paid time off to be vaccinated. And obviously they're going to have to provide proof that they've been vaccinated if they expect to be paid. So interestingly, the way things stand right now, if I present with COVID, then I'm not allowed to come to work. Okay, or if I'm at work, I need to be isolated, and you must remove me from the workplace as soon as possible. Now, in terms of this direction, that doesn't apply to an employee within the first 3 days after they've received the vaccination, for obvious reasons. You go to my next slide. Okay, so now we get to the meat of this discussion. Okay, so the directions have an Annexure C, and Annexure C provides a guideline as to what you'd have in your mandatory vaccination policy. So that's the purpose. Also, it's something the courts are going to look to when they've got to determine the fairness of a vaccination policy and how it's been implemented. So what are the key principles? And this is probably the most contentious issue. Okay, so what are we balancing here? We're balancing health imperatives, those speak for themselves, the efficient operation of the business, again, by extension, the economy. If I can't operate because my employees can't come to work, then it obviously affects everyone badly. And then there's the constitutional rights of the employees. Okay, and here again, we've got another balancing act within the balancing act, because we've got the rights of employees to life, to a safe working environment, and I'm talking about those who want to be vaccinated, versus the rights of employees to bodily integrity, freedom of religion, the constitutional rights, and that's in respect of employees who refuse to be vaccinated. So in terms of the Annexure C, what must your plan have in it? So you need to identify which employees have to be vaccinated. So it's mandatory vaccinations, not necessarily for everyone, but for the categories that you've identified should be vaccinated. What do you do in your plan? You tell them that they have to be vaccinated, and you tell them by when they have to be vaccinated. You also tell them that they have the right to refuse to be vaccinated, and there are two grounds basically, constitutional grounds or medical grounds. And you allow them an opportunity if they want to consult with the trade union or the health and safety representative. And then in terms of assistance, obviously paid time off. Also, if reasonably practicable, you should transport the employees to and from the vaccination sites. Oh, sorry, there we go. Okay, so what if an employee refuses to be vaccinated? Okay, what does the direction say? And I suspect that most of the questions will probably be around this issue. So there are two recognized grounds for refusal, like I've said. Constitutional or medical grounds. Okay, so if the employee refuses, there's already a process for you as an employer. Counsel the employee, I guess, understand their reasons, and if necessary, let them get guidance from a trade union or a health and safety committee. If it's medical, okay, you can refer them for further medical evaluation to see whether the contraindications are valid. And then, if necessary, take steps to reasonably accommodate the employee somewhere where they don't need to be vaccinated, but they can continue being employed. What's reasonable accommodation? So the direction provides a definition. It's not really anything new, It says you must look to modify or adjust the employee's job or the working environment so that you can allow them to remain employed. The adjustments that are mentioned in the direction include working off-site. Okay, we've already got that, the work from home scenario. Can they work in the workplace but in isolation, i.e. in an office that nobody else has access to? Can they work outside of the ordinary hours of work, so come in when everybody else has gone home? And if they have limited contact with others in the workplace, can they wear a N95 mask? So that in a nutshell is the direction. I suspect we'll unpack it a bit more in the Q&As. I'm now going to hand over to my colleague in Nairobi, Desmond. Thanks.
Yes, thanks, Jose. So let me just quickly. I'm a partner in the Dispute Resolution Department in our Nairobi office, and it's an honor to be here. Welcome, everyone. So I'll be looking at the interplay between business rescue and retrenchment in the context of Kenya, and I'll adopt the same format which Toby used by just starting to look at what the objectives of administration, which is the business rescue regime, what you would call business rescue in South Africa, and then I would then go on to look at the role of the business rescue practitioner, and then I'll look at the obligations towards the employees. So just to begin, so administration, just like business rescue, the whole objective of administration, the primary objective is to maintain the company as a going concern, and this has an implication on the role that it imposes on the business rescue practitioner towards the employees. If the company cannot be, sustained as a going concern, then the other objectives can be considered. But for our purposes today, we will look at the first main objective. Now, when a company goes into administration, there is no automatic dismissal of the employees. The administrator has to take a deliberate step to either declare the employees redundant or to declare the employees redundant. So the employees automatically continue on with their contracts as it was before. Now, the role of the administrator upon appointment as the administrator, the insolvency practitioner, his role, first of all, is just to conduct an investigation. And that investigation is primarily the financial status of the organization. So he'll be looking at the statutory statement of affairs that has been prepared by the directors to see the health of the company. But he has to go beyond that. He has to conduct a due diligence. And one of the issues that he has to look at is the HR component as well. And the reason this is important is that for him to be able to succeed in turning around the company, he has to assess whether the HR component is operating efficiently. Are there duplication of roles, which may need to be restructured. It is not a mandatory requirement as compared to the South African position, but it is a practical requirement for the administrator to consider that at the very outset. And the reason for this is because the administration period is very short, and you find that the administrator only has 12 months, or in certain cases if it is extended by the court or by consent of the creditors, it can be extended by another 12 months, so to make it a total of 24 months. And at the end of that period, the administrator has to turn the company back to the directors to continue running it as a going concern. So because of that limited period, the administrator really has to consider the HR component at the very outset and come up with a redundancy plan if that is necessary. Now, if the administrator finds that there's a job restructuring that needs to take place, then there's greater freedom to do that in the context of an administration in Kenya. And the greater freedom here is that the administrator is not required to hold consultations with the employees. So this is in contrast to the South African position, where there's a statutory requirement to hold consultations. Then the administrator is not required to consider seniority or skill or ability or reliability of the employees that would be affected by the contemplated redundancy. His main objective is just to look at the business efficacy, what makes business sense. And so he's not shackled by the normal redundancy requirements that you'd find, in a normal situation when a company is not in an insolvency situation. So once the administrator has prepared the the redundancy plan, that will be part of his statement of proposal, which will be presented to the creditors, and the creditors can then now make comment of it, in addition to the other proposals for restructuring the liabilities of the company. Sorry, I hope you can see my slides that seem to have frozen. So now, what is the implication to the employees? If a redundancy is to be effected by the administrator, then what the employees are entitled to get, one is notice pay, secondly is unpaid salaries up to the extent of 6 months, and then leave pay, any accrued leave that has not been paid. And this is only recoverable from the National Social Security Fund. So it is not a liability of the company, but it is something that is recovered from the fund that has been set up by the government for that specific purpose. So that is good news to the administrator, who may be operating on a shoestring budget, but it's not so good news for the employees, and I think which is a point for debate. Then the other controversial bit is that during administration, there is no severance pay that is given to the employees. The Employment Act expressly excludes severance pay for being payable to the employees who've been declared redundant. They are only entitled to unpaid salaries up to the extent of 6 months, and the other two payments that I've mentioned. Then finally, what is the implication of this to potential investors who may want to acquire a distressed company? Well, for the investors, it's a good opportunity to acquire a distressed business while it's under administration, because you do not have to comply with the rigors, of compliance with consultation or compliance with the usual compliance requirements that would be applicable in a normal redundancy situation. And then the other main advantage is that you have a clean slate. The liabilities that would be paid out to the employees are social security the same. It is also advantageous.
Right, Desmond, I'm sorry, I've just lost you towards the end there, so I hope everybody can hear me. There might be a connection challenge, but thank you very much for your contribution. I see there are some questions for you that I'd ask you to handle on the text, and thanks very much to Toby for doing the same. I'd like to call Jose back to screen, because Jose, I suppose, unsurprisingly, there are a couple of issues that I think it would be good if we take now before we go into the tea break. And the one relates to the let's call it the broad constitutional question. Isn't this a limitation of people's constitutional rights? And I've asked Riola to put on the chat the various constitutional rights that might be implicated, but importantly, of course, people seem to forget quite quickly the limitation of rights, the Section 36 limitation. Of course, that has to happen by way of a law of general application, but I'd like to hear you on that. And then the second theme that has come through is the confidentiality of employees being forced to disclose their vaccination status to their employer.
Okay, let's deal with the constitutionality issue first. Okay, we all know about the limitations clause. Constitutional rights aren't immutable. The complication here is you've got so many competing constitutional rights. You know, whose constitutional rights do you look at? Do you look at the rights of employees who value their lives or think it's important that everyone be vaccinated so that their right to life is not threatened? Do you look at, you know, the minority rights, i.e. the refuseniks or the anti-vaxxers or the hesitant population, and their right to bodily integrity and freedom of religion, whatever it is? It's a balancing act, okay? And then also the other concerns as well. Okay, there's the community concern, there's the health imperative concern, there's the concern of the employer. How do I run my operation, especially if you're a frontline kind of operation? If I introduce this risk, you know, there's the occupational health and safety obligations. I need to create a safe workplace. How can I do that if I'm a frontline employee and employer rather, and I have people who are refusing to be vaccinated? So, you know, you weigh up these constitutional rights and you look at all these different interests, and in the end, I think that you legitimately can terminate the employment of somebody who refuses to vaccinate, depending on the circumstances. The second question, just run that by me again. I've lost my train of thought.
Just about whether employers can force employees to disclose their vaccination status. So again, it's the same balancing act of employees being able to say, but this is my confidential information, and I don't want to tell you whether I've had a single shot or double vaccination.
Look, I don't think you can force employees to disclose their status. There's also a POPI issue there, which I'll leave for the POPI experts. But my view is always there's nothing stopping you from asking. You know, if they're going to volunteer the information and assist the process, you know, you win. If you don't ask, you're not going to get there. But yeah, I guess there are privacy issues and concerns. But you also required by the directive now to, for example, ask your employees whether they suffer from any comorbidities, etc. So, you know, you're certainly allowed to ask. I think that's the short answer.
Thanks very much, Jose. We're going to ask you to handle some of the other questions in the chat feature. I suppose so much of the broader constitutional issue is going to turn on what public policy dictates, and that ultimately is going to be very interesting to see how that Section 36 limitations exercise is going to be handled. There's seemingly a crash course that's going to take place between government, big business that are moving. I saw an article today talking about the snowball of movement towards mandatory vaccination, and some reluctance on the part of trade unions, for example, also in the universities context, saying no, but you can't just trample on people's rights. Now the question is, of course, people's rights have been trampled on in our constitutional dispensation, but in a justifiable way. For example, religious rights relating to corporal punishment of children at school. Now the question is going to be, how do those factors, and that's why I'll ask Riola actually to set out the full Section 36 limitations clause, including all the sub-factors, because I think that's going to...
You're talking about the snowballing effect. I read an interesting article just recently. Halton Cheadle, who's a well-known trade union lawyer, is actually saying to trade unions, it's your obligation to get your members vaccinated. Which I think is right, because the thing is, what's of paramount importance here? That people have livelihoods so that they can look after their families. If businesses close down because people, or not close down, if you inhibit the ability of a business to trade because you're going to encourage, refusals to vaccinate, etc., it's not in anyone's interests. So that obligation is broader.
Yes, and I think there are going to be such interesting parallels and nuanced distinctions, and this is where solid legal advice is going to be important, because I see questions relating to possible discrimination in the employment of people. Now this is subtly different, but I think crucially different from, for example, not appointing somebody because they're pregnant. This could have a different spin or nuance on it. So it's going to be very, very interesting to see what type of questions interviewers pose to candidates and how they deal with this issue.
Yeah.
But Jose, thanks.
Okay. I was just going to say the test again with discrimination is it's unfair, and I think that'll come up in the wash, I guess. Thanks, Avinash.
Well, thank you to you and to Toby and to Desmond as well. I'm going to ask everybody just to take a slightly shorter break so that we can catch up some time, and if we can reconvene in precisely 5 minutes, so that's just after 22:11. Thank you. I hope you grab something nice to drink in the few minutes available.
COVID-19 is one of the biggest crises of our time. It has impacted every single one of us, shaken our social systems, and disrupted every sector of our economies. The automation of work, combined with a global recession, led workers to lose their jobs at an accelerated pace compared to previous years. And this trend is expected to continue. The ongoing shift in the division of labor between humans, machines, and algorithms might displace 85 million jobs worldwide in the next 5 years, while 97 million new roles, ones that are more adapted to this new task distribution, may emerge. By 2025, companies expect to displace roughly 6% of their total workforce. 1 in 2 workers will need reskilling, and those remaining in their current roles will need to update 40% of their skill set to adapt to the changing labor market. There is a way to collectively benefit from these challenging times. Decades of research have shown that the most valuable asset of any economy or company is its human capital. Around the globe, companies are already experiencing a shortage in relevant skills for future roles and are investing in reskilling and upskilling their workforce. By 2025, organizations say they will train over 70% of their employees to ensure they can smoothly transition into the jobs of tomorrow. These include DevOps engineers, artificial intelligence specialists, digital marketing managers, talent acquisition specialists, and customer success specialists. It will take on average between 2 weeks and 5 months for workers to pick up new skills, allowing them to move into these new roles. But data shows they won't need to have the perfect skill set to start transitioning. While 2/3 of employers expect to get a return on investment in employees' reskilling programs within just 1 year, governments will also need to step in to update and fund education and training systems and to ensure displaced workers have adequate safety nets. With purposeful leadership and collaboration, we can turn this global crisis into a unique opportunity to transition into a future of jobs that is inclusive, fair, and sustainable.
Ladies and gentlemen, I hope you've had a good break, albeit a very short one. Our next session considers the evolution of employment agreements in the next normal, as well as aspects of the gig economy. The pandemic seems to have diluted the focus from issues such as transportation, network drivers, and gig economy work. That seems to have been yesterday's problem, given the issues of mandatory vaccinations and the like that we've just been dealing with. But nevertheless, strategizing on finding the optimum way to deal with these dimensions of the next normal needs to continue. And this needs to be overlaid with lessons from the manner in which work has continued throughout the pandemic. So is working from home a fad? Is this something that employers must get used to and embrace, possibly on a permanent basis? It would be interesting to survey managers on the one hand and employees on the other, and see which group, if any, wants to come back to physical work. Gillian Lum, Jerry Wagacha, and Michael Yates will deal with these issues and more.
Thank you, Avinash. As Avinash said, one of the things that we've got to deal with going into the next normal, the period after COVID-19 and the era that will follow COVID-19, is dealing with remote working and whether we're going to, in the future, look at continuing those relationships or those arrangements, or whether in the future we will be looking at changing those and developing hybrid models where employees will potentially be working sometime from home and sometimes from an office. And I'll also be looking at the gig economy and atypical working arrangements. With an increasing number of people participating in the gig economy and atypical working arrangements, we need to consider our labour laws in South Africa and whether they will be able to respond to the change in our labour market. So if we can deal firstly with what we face going forward, in particular whether we're going to include in the next normal, the period after COVID-19, the working from home and remote working. So in this next normal, as I say, we anticipate that we will be working potentially remotely, continuing to do so, an increase in automation with a corresponding increase in job losses, a continued drive to reduce costs, where we've had employers who have large buildings, large overhead costs. They may be looking at trying to eliminate these costs or substantially reducing these costs, and also a desire to retain flexibility. Employers who retrenched employees during the pandemic, who now may be experiencing post the pandemic an increase in demand for their production, notwithstanding this may be reluctant to re-employ employees on a permanent basis and may want to retain flexibility going forward. All of this means that full-time employment relationships, where an employee clocks in at an office and works 8 to 5, will continue to decline into the next normal. So what do employers need to consider when it comes to remote working and whether they're going to continue those arrangements? Firstly, the context of employment. The starting point is, what does that specify in relation to the place of work? Does it specify that an employee has to work in an office building? Will the employer need to potentially negotiate and agree with employees to a change in their place of work? We've obviously had during COVID a unique situation in which employees were forced, because of external factors and government imposed regulations, to work from their homes. But into the next normal, we'll need to potentially have to negotiate those changes and agree those changes with employees. So what employers need to consider then is, will there be resistance from employees? If you're requiring employees to come back into the workplace, that may have an impact for employers, where certain employees who've enjoyed flexibility while working from home may resist being called to come back into the office. And you may have a situation where that then pushes or drives people to look for other employment opportunities where they can work remotely. If you're going to include remote working going forward, you need then to consider the form that it will take. We've had during the pandemic situations where people don't have the flexibility to work anywhere but from their homes. But going forward into the next normal, there is the potential that people could work from a coffee shop or a shared workspace. And you need to consider, if people are going to work remotely and be allowed to work outside of their homes, whether that will then adequately protect your confidential information and ensuring that you've got policies in place then that safeguard that data. One of the disadvantages that you need to take into account when determining whether employees are going to work remotely on an ongoing basis into the next normal is collaboration, and what is the impact that it has on people working as teams and being able to collaborate. And I think there we need to look at what mechanisms can we introduce. Will it be a hybrid model where employees will from time to time have to come into the workplace so that they can collaborate and work together as a team? The other issue, which is adjunct to this, is the culture of an organization. If you have an organization where the culture is something that's entrenched, it's a positive and valued culture that you want to continue into the next normal, one of the considerations then is, how will you inculcate that culture with newly appointed employees who never come into your workplace potentially? They're working remotely, they don't come into the environment. How do you ensure that that culture continues into the next normal? One of the major advantages of having remote working going into the next normal is the ability to expand the talent pool from which you can draw on to hire people. There's obviously potential going forward that you could hire people who never come into South Africa or Kenya, who will work from remote locations, and that those arrangements are far more accessible and available to employers now. The considerations that one then will need to take into account is whether you will then be having South African or Kenyan law applying to those employment relationships, or whether it'll be a foreign jurisdiction's legislation that apply, and also which courts they will fight those disputes in if disputes are raised. So that's dealing with remote working and some of the considerations when taking into account the next normal in remote working. I then want to talk about the gig economy and atypical arrangements. As we all know, there's been a massive escalation in unemployment and unemployment figures. Stats SA released unemployment figures that are a staggering 34.4% in the first quarter of this year. And that's undoubtedly increased the number of people that are moving into atypical working arrangements and entering into the gig economy and working on digital platforms. As we know, the gig economy involves individuals that are working and being paid for short-term periods. They are paid per gig or the job that they perform. And it includes many of the digital platforms like Uber, Bolt, and SweepSouth. And the scarcity of jobs in South Africa has meant that these digital platforms have played a critical role in ensuring that people can continue to earn an income, notwithstanding the pandemic and into the next normal. Advances in technology have also meant that a larger group of people than historically have been able to now access the gig economy and work on these digital platforms. The second consideration, not only in relation to people entering into the gig economy and the need to create employment opportunities or opportunities to earn income, is also an ongoing desire for flexibility. So as I said earlier, many employers are wanting not to have permanent employees in their organization. So that increases atypical arrangements where employees are potentially engaged on a part-time basis, or you have self-employed people or fixed-term individuals and seasonal work. And this raises the critical question as to whether our law in South Africa, and our labour laws in particular, are able to accommodate this change in our working and our labour environment. Our labour laws in South Africa in particular have been drafted primarily to protect employees in traditional full-time employment relationships. As we know, in the gig economy and people working on digital platforms, many of those individuals are contracted as independent contractors rather than employees. And in terms of the Labour Relations Act and the Basic Conditions of Employment Act, the definition of employee expressly excludes independent contractors. So what we now face with is a situation where we need to understand whether our laws will be able to grapple with those situations. As we saw in the decision before Verniekerk in the Labour Court involving Uber SA Technologies, a judgment in which we were involved acting for Uber, the judge said the following: in the nature of the engagement of drivers who use the Uber app, and indeed the many others who provide services in what has been described as the gig economy, this poses a challenge to traditional conceptions of employment worldwide and has tested the boundaries of the protection extended to working people by domestic labour legislation. And as he said, this is something that not only our courts locally are having to grapple with, but also internationally. And this has resulted in some bodies in South Africa calling for specific dedicated regulations for platform workers, rather than simply extending our existing employment legislation to cover platform workers. We've also seen over the years, though, as our laws had to grapple with the situation, amendments the legislator has posed to and brought about to our legislation. We've had amendments to the Labour Relations Act, where there's protection now for so-called vulnerable employees, the TES employees, they're deemed to be employees of the client, and fixed-term employees with their restrictions on those contracts. We've also had the introduction of the rebuttable presumption as to who is an employee and placing an onus on the employer to establish, if one of the 7 factors is triggered, that they are not an employer in that relationship. And more recently, we've had the introduction of the national minimum wage, which covers the wider spectrum of worker rather than the more narrow employee, which expressly excludes independent contractors. And this process is continuing now. In July of this year, we've seen the South African Law Reform Commission publish a discussion paper where they're looking at extending the benefits under the Basic Conditions of Employment Act for maternity and parental leave to self-employed workers in the informal economy. Their primary concern there being that often the current legislation discriminates unfairly against women and Black people who form the majority of those who participate in the informal economy. And if these proposals are implemented, it's contemplated that there'll be a widening of the definition of employee in the Basic Conditions of Employment Act when it comes to these specific provisions relating to maternity and parental leave. So in conclusion then, I think what we need to face in the new normal or in the next normal is that all of us are going to need to be agile and adaptable if our businesses and our working relationships are to survive. And that it may well be that our legislator is forced to revisit the definition of employee in our labour laws. And all of this adaptability then takes me into the topic of my colleague Njeri, which looks at managing performance and discipline remotely. If I can then hand over to Njeri. Thank you.
Njeri, you're on mute.
Trying to do too many things at once. I hope that you can see my screen.
Yes.
Okay, good. So I think, you know, in line with what we're discussing in terms of remote working is, and the fact that people are working from different places on the continent and far beyond, is the importance of knowing how to manage performance and discipline when people are working remotely. How can you assess whether your employee is working to the satisfaction that you want? What is it that you're expecting of them when they're working remotely? And how do you manage the disciplinary process in that time period? I mean, remote working is the next new normal, as Gillian has explained. And what we're trying to do is demonstrate that continent-wide, as we are practitioners on the continent, there are different approaches to what is considered, managing the disciplinary process, and therefore the importance of knowing where your employees are, what the effect of a disciplinary process in a particular jurisdiction means, and the fact that there's no one-size-fits-all for all of the countries that we cover as employment practitioners. Yeah. To assist with this, we have compiled an Africa-wide guide covering 19 jurisdictions in Africa, specifically focused on remote working, and we will be publishing that guide, at the end of this month, or in, I think, early October. But in any case, it demonstrates the importance of employers considering these practicalities now and knowing what the implications are as they seek to navigate the employment, the new normal, really. So let me focus first on remote working and managing performance. And really what you're talking about here is managing the employee and knowing whether, first of all, it's an employee situation or whether it's an independent contractor, and what control you have over that employee, therefore. Yeah. So we're talking about the employee knowing that in their employment relationship, they're going to have specific set targets for what they're supposed to be doing. Ethiopia is spotlighted as a country whose employers benefit from the use of performance management method, and there are no regulated processes for managing performance remotely there. Yeah, but in Kenya that would be different, and it would be different in Ghana, for example. Yeah, setting clear timelines for and using remote monitoring systems. Are you monitoring what the employee is doing on a day-to-day basis? How does that offend data protection or even privacy within the employee's home? In the CDH, our remote working guide, we discuss how Botswana has used this successfully, remote working monitoring systems to know whether the employee is working correctly, and that has been said to be acceptable in Botswana. Perhaps it wouldn't be in another jurisdiction. Yeah, we're also talking about giving regular feedback to employees on their performance and what they're doing within the workplace. So, for example, we discussed in the remote working guide Ghana, where employees are advised to employ this method and go further to undertake employee assessments to determine performance and eligibility for working from home. So from the get-go, you're saying, are you the type of employee that I can trust to work from home? Yeah. As a general guide, we need to look at what the employee relationship is, yeah, and what advice we would be giving to our employers or our clients on what they can do to make sure that their employees are, working to the standard that they expect. Yeah, an employer can ensure that performance is carefully monitored by reviewing and discussing their expectations. So, what is expected from the employee? Discussing how the employee intends to meet those outcomes. So, is it working 4 hours and then taking a break, and is there flexibility in that respect, or is it just working 9 to 5 as normal but from home? Discussing, agreeing on specific timelines and when the work is expected to be completed. Discussing whether monitoring systems are acceptable. Does the employee know? Is it a covert monitoring system that the employer is using? And does that have any impact on legislation that is currently in place in that country? Giving regular feedback to the employees so that the employee knows what is expected of them. And then just checking, intermittently whether the remote working environment is actually working, yeah, for the employee and for the employer. So it's a mutual relationship. For an independent contractor, we're talking about what is the scope of work that you're requesting of the employee. Are they supposed to be working or 100% dedicated to your business? Are they supposed to be 100% dedicated to other businesses? Are they working, are they doing just 2 hours of work for you? How much supervision and control do you have over their work? Have you provided the tools of trade for the work? And is the employee an essential part of the business? There's a lot of advice that we're currently giving on independent contracting. What are the effects of an independent contractor relationship, especially where taxes are concerned? I think a lot of businesses have sought to use independent contracting as a way of vitiating their obligations in relation to tax. The taxman is especially in Kenya, reinforcing and making sure that when you say it's an independent contractor, it's actually an independent contractor, and not someone that you're just using that title for. So it's substance over form is the test there. Yeah. And so all of these considerations come into play depending on your jurisdiction. Yeah. So I wanted to just focus a bit on managing the disciplinary process if you then are not satisfied with what the employee has been doing for you. And I also want to focus on the case law in the jurisdictions that I've highlighted here. So Ghana, Nigeria, Uganda, Kenya, Tanzania, and South Africa, just to give you a flavor of what we're talking about. Yeah. So your employee has been working remotely. You're not happy with what they've been doing. You want to now discipline them. And how do you do that? And how do you do that successfully? In South Africa, there's a concept which my colleagues have explained to me of a decriminalizing the hearing, which means basically that when you're disciplining an employee, it is in a formal way, and it is in a way that there's a charge sheet. The employee has an opportunity to bring witnesses, so really running a mini trial. In a lot of African jurisdictions, however, and Kenya included, the process has been decriminalized. So it is not a trial of any sort. It's actually an opportunity for both parties, the employer and the employee, to understand each other and understand what has gone wrong and how to remedy that wrong, right? So it's not it's a decriminalized process. So that's what we mean by that, yeah? So that decriminalization involves notifying the employee of what has happened or what the disciplinary process is, and them knowing that if there's a consequence for a breach of their handbook or whatever it is that has been infringed upon. So let's talk about, let's say, coming in late at work, or non-performance, or something, or some kind of harassment or something like that. So knowing that this is against company policy, and I did not harass X, or I did not come in late, or I have performed adequately, etc. Carrying out the disciplinary hearing in a fair manner, so giving them an opportunity to prepare for the hearing, notifying them of the findings of the hearing in writing, and giving the opportunity to appeal the hearing. Yeah, so I'll give you a few examples of case law in this regard, and I want to start with Kenya, where there's a case of Joshua Rodney Marimba versus the Kenya Revenue Authority. So that's our tax authority, quite a high-level case. Here, an employer fails to properly constitute a disciplinary hearing according to its internal policy. So they had a policy, that policy was not followed. The Revenue Authority was accused of acting with bias and partiality towards the employee during the hearing, denied the employee the right to question his accusers, and failed to communicate the disciplinary process, and therefore that was in breach of the Employment Act. Quite a straightforward case. The employee was unfairly terminated, and that the consequences follow. So 12 months in damages for the employee. That's the normal. And then of course there's additional penalties for breach of constitutional rights that the employee can bring. Yeah. Nigeria, let's talk about the case of Ndukwe versus the Legal Practitioners Disciplinary Committee and another. This is a 2007 case. An employer failed to have the disciplinary hearing and proceeded to initiate criminal proceedings where the employee's offense doubles up as a crime. So it was not only a breach of the employment, but they tried to accuse the employee of a crime as well. Here, the employer was found to have failed to follow due process. The employer should have first sanctioned the employee for a disciplinary hearing before referring the matter to trial. Yeah, we're going to talk now about the case in Uganda. And it's a 2021 case, Batwala versus Madden Group. Here, the employer who fails to give an employee sufficient time to prepare a defense for a disciplinary hearing has failed to conduct a fair hearing. So basically saying that the employee needs to be given time to prepare a defense, or to prepare his arguments, or to show cause why he has reason to argue the case. A fair hearing, the court held, includes the employer's correspondence with the employee in the run-up to the hearing. Yeah. Let's go now to Tanzania in the case of Edwin Kasena versus Enza Zayden Africa Group. Yeah, all of these companies, high-profile companies, who do not necessarily need this kind of negative publicity. An employer who fails to investigate and properly record his investigation of an employee's alleged offense, fails to summon a witness during the disciplinary hearing, fails to explain to an employee the right of appeal, has failed to properly conduct a disciplinary hearing. So although the employer has valid reasons to terminate the employer must compensate the employee for unfair termination simply because they didn't follow the due process. Yeah. So even where the employee is working remotely, where even you have monitoring systems, where you want to discipline the employee, the recommendation remains that it is not acceptable to conduct a hearing without due process. It is not acceptable to not give the employee an opportunity to demonstrate or show cause why they should be disciplined or to defend themselves. It is not acceptable to give the employee no opportunity to prepare. And more important than that, the first step is to have a disciplinary policy that is followed and adhered to and is in line with the laws of whatever country you're referring to. As always, we're available to give advice to cover the African continent, and we will be providing that guide to you. So I can hand over now to my colleague, Michael. Thank you very much, everyone.
Thank you, Jerry. So share my screen. Fantastic. Well, thank you, everybody. I'm going to be dealing with some of the more nuts and bolts of the working from home scenario, where we've been speaking about the new normal and more in connection with the requirements and obligations of employers in terms of the Occupational Health and Safety Act. As we all know, the Occupational Health and Safety Act was legislated and is primarily intended to protect the health and safety of workers in the workplace. However, the concept of the workplace has somewhat been rattled over the last 2 years. And what exactly does that mean? What is the workplace? But before I get to that, let me just briefly speak about the general duties of an employer, which is encapsulated in Section 8 of the Occupational Health and Safety Act, which basically deals with the provision of a health and safe work environment for your employees. These specific duties that an employer may have would include the provision and maintenance of a safe and hazard-free system of work, plant and machinery, and we will be speaking about machinery a little bit later, because it's not the big industrial machines that you may be thinking of necessarily. Also, the elimination or mitigation of any hazard or risks or potential hazards in the workplace, and also the determining the risks to the health and safety of persons relating to any work that is performed, and establishing a precautionary measures that should be taken into consideration, and also providing the necessary information, instructions and training and supervision of your employees in that workplace. Now, just turning quickly to the to case law, the general duties of the employer has been reconfirmed in the matter of the Public Servants Association of South Africa on behalf of its members versus the Minister of Health, which was a 2019 Labour Court case, wherein the court reaffirmed that Section 8.1 requires every employer to provide and maintain, as far as reasonably practicable, a working environment that is safe and without risk to the health of its employees. In the Supreme Court of Appeal matter, in the matter of Intech Instruments versus Transnet Limited trading as South African port operations, the Supreme Court of Appeal held that Section 8 of the Occupational Health and Safety is preemptory, and that means essentially that a party cannot seek to try and contract out of its obligations in terms of the Occupational Health and Safety Act. So it's not really permissible for you to state in your contracts of employment, where you allow your employees to work from home, to say that you will be purely responsible for your own health and safety at home. You cannot contract out of it. However, the safety of employees in the workplace does not squarely fall on the shoulders of employers. The basic principle from the Occupational Health and Safety Act is that the potential hazards in the workplace must be addressed through cooperation and clear communication between the employer and the employees. Both parties must proactively identify the risks and develop control measures to make the working environment safe. And the drafters of the Occupational Health and Safety Act definitely could not have foreseen the impact that COVID-19 may have had in the workplace. So let's just talk about what working from home really means. When we talk about the COVID-19 regulations, we all know that during the start of the pandemic, the disaster management regulations required employees, where they can, to work from home. Now, one of the key questions that evolved is whether a person's home becomes the workplace if an employee performs his or her services from their homes. And this has important ramifications, both from an employer's obligations in terms of health and safety regulations, but also for the purposes of the Compensation for Occupational Injuries and Diseases Act. In other words, if you are injured at home, can you claim compensation for such an injury? Now, This is also very likely because, as Gillian has mentioned, we will be looking at a very different workplace in the future. And also, even for us labour lawyers, as you heard from what Cameron has said earlier this morning, we can even run your arbitrations from the comfort of our living room armchairs. But we will see how that goes. But in addition to all of this, there is definitely a drive towards a flexible and agile working arrangement, because this has been found to have merit, and that the working environment will become even more agile and flexible in the future. I mentioned that if you are injured at home in the workplace, that you could potentially claim under the Compensation for Occupational Injuries and Diseases Act. And I think that that holds true in that all injuries, whether they are fatal or non-fatal injuries, are compensatable under the COIDA Act, because COIDA essentially applies to all employers, regardless of the industry that you are in. So occupational diseases are also compensatable, and also occupationally acquired COVID-19 is also compensatable under COIDA. But what constitutes the workplace? And here I'd just like to look at a couple of definitions. In terms of Section 1 of the OHSA Act, the workplace is any premises or place where a person performs work in the course of his or her employment. In turn, work is also defined as an employee or as a self-employed person, and for such purpose, an employee is deemed to be at work during the time that he or she is in the course of his employment. Now, essentially, employees that perform work as defined at home will in most instances be acting in the course and scope of their employment, and therefore their residence or homes constitute the workplace for the purposes of the Occupational Health and Safety Act. Now, you would remember that I mentioned machinery earlier. Now, equipment such as laptops, computers, printers, whatever you may provide your employees in order to work at home will also constitute machinery. And we have a particular set of regulations under the OSH Act, which we call the General Machinery Regulations, which places various responsibilities on the user of such machinery. Now, in short, the user in terms of Section 1 means the person who uses the machinery for his or her own benefit or has the right of control over the use of such plant or machinery, but does not include the lessor or any person employed in connection with that machinery. So, what does that mean? In short, employees who are working from their homes would be considered to be the user of that machinery, and they would need to comply with the provisions of the Occupational Health and Safety Act and the General Machinery Regulations if they own that machinery themselves in their own right. However, if the employer provides such machinery to their employees, that obligation falls onto the employer to ensure that it conforms and complies with the provisions of the General Machinery Act, meaning that you must make sure that the use of that machinery is safe, that the employees are properly trained in it, and that that machinery doesn't cause any harm to employees. Now, it's difficult to imagine how a laptop computer might, for instance, cause any injury or harm to an employee, but you've got to consider things such as screen, whether there's glare on the screen, how that computer is being used, and we will speak about ergonomics a little bit later. Now, what are the provisions of the Occupational Health and Safety Act that apply to the home? Well, in short, the responsibilities are on a company in the capacity as an employer are not absolute, but are limited or qualified by what is reasonably practicable. Now, the term of reasonably practicable is essentially defined and includes 4 components, meaning the severity and scope of the hazard concerned, the state of knowledge reasonably available concerning that hazard or the risk, the availability and and suitability of any means that could remove such a hazard or mitigate such risk, and the cost involved in removing or mitigating that hazard or a risk. Now, the employer would be required to comply with the responsibilities as set out in the Act, which would mean that typically, under normal circumstances, the employer would have to conduct what we call a HIRA, or a hazard identification and risk assessment, It would implement appropriate measures to address such identified hazards and risks. It would implement an appropriate health and safety training and communication protocol. Typically, it would appoint competent supervisors and obviously implement a system of over-inspection. But when we talk about working from home, these normal responsibilities may look a little bit different. In this case, we would submit that an employer would have an obligation to at least carry out what we call an issue-based hazard identification and risk assessment. An issue-based risk assessment, or IBRA, highlights the typical hazards to which a person may be exposed while working at home and communicate these hazards and risks to the employees, together with procedures and instructions relevant to the identification of such hazards and risks. In other words, it would not be necessary for you as an employer to conduct an issue-based risk assessment in respect of each person's home or residence, but rather to identify the generic hazards and risks and to implement generic instructions to address the identified hazards assessed with, which have been assessed and associated with working from home. Now, it sounds quite ominous because it seems like all of these responsibilities fall on the shoulders of the employer. However, be assured that there is a dual responsibility, or at least a shared responsibility, in terms of employees, as set out in Section 14 of the Occupational Health and Safety Act, which states that every employee must take reasonable care for their own health and safety and of other persons who may be affected by their acts or omissions. Now, while the person's home or residence may be a workplace for the purposes of Occupational Health and Safety Act, and in the event that there is an incident, the employer will carry the responsibility to investigate what had occurred and what gave rise to that investigation. The lines can sometimes definitely become blurred. For instance, what would happen if your employee in the process of printing out documents trips over his poodle, falls down and breaks his arm in the workplace? Would that constitute a workplace incident or not? Or if an employee slips on a wet puddle in his or her passage and sustains an injury, would that be construed to be an occupational injury? It's all based on the circumstances of the matter, and you would have to determine whether the injury was sustained in the course and scope of employment. But in relation to your issue-based risk assessment, what the employer would typically do is it would address basic themes such as fatigue management, illumination, such as screen glare, ventilation in the workplace, ensure that your employees have sufficient ventilation, equipment such as laptops or printers or cutting equipment or anything that your employees may be using, and any slip or trip incidences such as stairs or anything of the sort. Of course, your issue-based risk assessments would also have to take into consideration the effects of COVID-19, and if there are any particular requirements, such as if customers are going to see your employees at their homes, what they need to do in terms of COVID, complying with the COVID-19 regulations. In short, appropriate procedures and instructions and communications should be made available to your employees, even if it is in a generic fashion. You can, of course, also educate your employees in order to do their own assessment if there is a need for that. But if your employees are going to do their own assessment, please ensure that they are adequately trained and have sufficient knowledge in order to be able to conduct such a risk assessment at home. Now, in the event that there is a workplace incident, we can just turn briefly to the provisions of the COIDA Act, where Section 23 says that where there is a serious or willful misconduct of an employee, no compensation will be payable in respect of a workplace incident unless such an incident results in such serious disablement or death that leaves a dependent family wholly financially dependent on the employee. In such a case, there may possibly be a claim even if the employee was willfully and grossly negligent or acted in a wrongful manner. In terms of Section 22, sub 4 of COIDA, an accident is deemed to have arisen out of and in the course and scope of employment if an employee, notwithstanding the fact that employee was at the time of the accident acting contrary to any law or instruction or order, or was even from his employer, or was even acting without any order from his employer. If that employee was, in the opinion of the Director General of the Department of Employment and Labour, acting for the purposes of or in the interest of his or her employer, that would be deemed to be an injury sustained in the course and scope of his employer. So if you have an employee driving a vehicle, breaking the law because he was speeding, and he is involved in an accident, but he was in the course of delivering something for his employer and furthering the business of his employer, that employee may still have a valid claim under COIDA. Now, I'm going to turn briefly to sorry, I see Avinash is going to stop me.
I can stop you and ask you to hold that last contribution and to share that when you share the slides. I'm just mindful of our time. I noted that you very kindly didn't mention to all the parents when they're tripping over their children and suffering from the noise pollution of screaming children when they're trying to conduct team and Zoom calls, and whether that's a occupational hazard. But it really struck me in actually not only your presentation but in Jerry's and Gillian's as well, as to as much as we're talking about the next normal, so much of your presentations were actually based around the fundamental concepts, in your case of the definition of a workplace, and in Gillian's case, and Jerry referred to it as well in the guide that is being produced, the definition of an employee. So it's amazing that as we talk about the next normal, understanding of the fundamental principles and the development of the fundamental principles remains crucial, and I think that is something that we shouldn't forget as we take this discussion forward. But thank you very, very much to Michael, to Gillian, and to Jerry. We're going to change gears and talk about strike law and collective bargaining, because that continues to play its part in the employment landscape. You heard me refer earlier to the collision course that employers and trade unions might be on in respect of mandatory vaccination. But the recent experience of civil unrest, the consequent loss of life, property and investment, has added a malicious tone to these debates. And as always, again, staying abreast of the recent case law in this fast-moving area is crucial. Fortunately, we've got Hugo Pienaar, Tabang Rapoleng, and Bongani and Masuku to talk you through the latest developments. Over to them.
No. Good morning, honourable friends of CDH. So I'm equally honoured to have with me Tabang and Bongani, and sitting next to me is Asma Kachalia, assisting us with the slides and ensuring that everything goes smoothly. So may I just removed my surgical mask, and may I just share with you the pain older people have. So whenever I wear these masks, people would ask me, oh, are you going for plastic surgery? And your friends would ask you, oh, are you going back again for plastic surgery? And then your enemies would say, I can assure you, you have a sound case for deformation against your plastic surgeon. So that's the life we're living at the moment. So what I'm going to do in terms of the topics that we're going to present, in my case, we're going to deal with 3 topics. The one is, of course, the issue of picketing. The second one is about ultimatums, and the third one is about the sympathy strike. So let me go straight into some principles which I think can give you a sense of what will happen in the future. So we've seen wage demand or wages being settled at a relatively low level, and I say relatively, and sometimes for 3-year periods, which means that the premium that you would usually pay for the second and the third year agreement starts off at a relatively low base. Of course, that creates fertile ground for trade unions or new trade unions to come in year 2 and year 3, looking for confrontation, getting membership up, and telling your workers that they've been sold out. And of course that creates a problem, because all of a sudden we know that our wage agreements will be challenged, and more in particular the no claims clause. And again, I can't emphasize enough how important that no claims clause is. I know at bargaining council level it's more difficult to manage, but at plant level it should be clear that there can be no claims that sound in money for the duration of this agreement. And I think it's important that those provisions should be made in your agreements. The point on picketing, we know that that is the best weapon for most unions during a strike, and we know sadly that many of those picketing lines are conducted in a violent manner. And we know that there are two things you'll do. Is your first application will be, of course, you'll record all breach of picketing rules, but you'll go to court and ensure compliance of the picketing rule. And your next one would be to actually interdict the picketing, prevent employees from picketing, as we've done in many cases. What is important about that is before you do your second picketing, provided you can bring in replacement labor and the like, is to have your lockout in place. And our experience is that that then becomes a very effective tool. The third point I think that one must consider is the issue of concession bargaining that may come into play and that we've not seen. In other words, where people will say, I'm going to negotiate, but I need to reduce wages. And you will not see it at bargaining level, but maybe at some plants where it's about job losses and survival. Of course, you only see employers doing that when they can bring in replacement labor and where the community at large would allow them to, in fact, bring in replacement labor. So when we deal with picketing specifically, we know that the notion of unions or generally would be that I'm not going to picket, I'm not going to commence with my strike unless I can picket. And we know that a strike delayed is a strike denied, and often employers use the tool provided for in the Act to delay picketing rules being finalized, such as when you have picketing rules, you need the owners, especially when it's in malls and the like, you need the owners or controllers of that property to be present. We've had cases where we've had 58 people from the malls present. In other words, the controllers of the property when setting picketing rules, and of course that delayed these proceedings significantly. So when we look at picketing, and just given our limited time, I have 7 minutes, look at the default position on the picketing rules. There's a default picketing rule, and when it deals with weapons in particular, you would be happy to know that golf clubs and the like are not specifically mentioned, but these would refer to the following specifically prohibited: knives, spears, pangas, bush knives or similar objects, sticks, knobkerries, anything made of wood or metal, so they don't draw a distinction, whips and shamrocks, bricks, stones, or any similar object that can throw or propel in a manner that can cause injury, inflammable substances, and any liquid that can, of a similar substance that can be sprayed that may cause injury or damage. You'll recall the last time we shared with you the person with the capital that shot out the video camera, and his defense was that it was during the 4th week of the strike and they were hungry, and hence there were birds sitting on the fence next to the camera, and he accidentally hit that, the camera. So the important thing is, therefore, when you do your picketing rules, look who may participate, look at the numbers, look at the fallback situation so that you have that as a basis. But more importantly, is my experience, we must look at the role of private companies. We've seen private companies causing big damage, serious damage to strikes when they go overboard in the so-called attempt to protect property and the like. And the case law, it's not about vicarious liability, but make no mistake, there will be ways in law to establish some sort of liability if you don't ensure that there's proper compliance with respect to people and property during such period. So that is about picketing. Have your draft picketing rules in place if you don't have it in the collective agreement or otherwise. Good. Second one is about ultimatums. And what do we know about ultimatums? It must be clear, it must be sent to employers and unions, you'll communicate with them, you'll tell them what sanction will be imposed and all of that. follows Steve Spar case, the I think it's just a case of about 2020 or 2000 ILJ 519, David points out to me. And remember what you put in your ultimatum, it's almost predicting your pre-trial hearing before court. And you say, tell me, we say the strike is unprotected, tell me why you say the strike is protected. We intend to terminate, tell me why we shouldn't terminate. That's critical that you have that in your ultimatums. You should have a set of ultimatums readily available that complies with the rules so that when you're in a situation, I'm talking about an unprotected strike, that you're ready to issue. Now, the case here on point is, of course, the LAC case of Samanco, where they issued those ultimatums and warned them of discipline, but the ultimatums weren't clear. Employees then returned to work, and some of those who returned to work were dismissed. And the court made the following points when it dealt with the role of the ultimatum. It says, what is the purpose of it? Firstly, is to get collective orderly bargaining back in place with the focus on orderly. And the second one is, of course, to address the issue of misconduct. But what the court said, and this is important for us, it says, our law regards an ultimatum by an employer as a waiver of its right to dismiss for the period of the duration of the ultimatum. So be clear, if you want to take discipline, often it says, if you do return to work, we reserve the right to discipline. Be careful how you phrase it, be careful if you still want it in your ultimatum or not. But it's clear that there's a sense that once you've issued the ultimatum and employees return within that period, that the court said in this case, it regards the ultimatum as a waiver. Let me quickly then touch on the minute that I've left on sympathy strikes. Now, we know that, and this is my sense, given the latest judgment, or this judgment, that in time to come, unions would be more cautious to issue notices in terms of sympathy strikes, and if they do, it will be for a shorter duration. It won't be for an open-ended period, and they will reconsider the number of people and even the number of companies they're going to cite in that sector for the purpose of a sympathy strike. So, just stop this. So, when we look at this case, it said what, and it went into the proportionality test, where they said historically, and the case didn't deal with that, but historically we know that the court simply looked at the nexus. Was there a nexus between the primary and the secondary employer? Did you provide steel to the secondary employer? Yeah, there's some sort of nexus. But let's just listen to the wording of 66(2)(c), and it says the nature and extent of the sympathy strike, or the secondary strike rather, is reasonable in relation to the possible direct or indirect effect it may have on the primary employer. And hence the court developed and looked at this concept and said, let's have the proportionality test and let's consider the following factors when we want to interdict the sympathy strike, i.e. the duration of the sympathy strike, the notice, the number of employees involved, the conduct of the employees, the impact on the secondary employer, but also the impact on the primary employer, and of course the impact on the sector. So if you have a marginal employer, that is a factor that will come into play when you deal with sympathy strikes. And that concludes the bit on my half. I can only wish you peaceful industrial action to come, and thank you for attending the conference. I now have the honor of handing you over to my partner and that is Tabang, and he will take the issue further on civil unrest and the like. Thank you for your time.
Thank you, Prof. I will be dealing with the issue of dealing with discipline during a strike and as well as during civil unrest. Misconduct during strikes is a cause for stress for many employers. The misconduct will usually take the form of intimidation, damage to property, assault, even the killing of people in certain instances. The Labour Court has seen a number of strikes that have turned violent, and one can think of the one in the case of security services employers' organizations against SATAWU. And in that particular strike, it was reported that about 20 people were thrown out of a moving train. Most of them were security guards who were targeted by their striking employees, and unfortunately 2 of them died. And more recently in NUMSA, on behalf of Operate Dludlu, against Mali Pipe Systems. In that particular case, more than 100 employees were assaulted by striking employees. So sometimes strikes become protracted, and this presents several challenges to the employer, such as if there is misconduct, the collection of evidence becomes an issue. The common ways of collecting evidence will include taking photographs, taking videos, keeping a diary log of the events and the movements. But we all know that sometimes these are not sufficient, and the photos might present challenges such as being blurry, and you might find that the CCTV footage images shoot from far and so on. Now the question is then, what happens to those employees who participate in such acts of misconduct? And that's where now the doctrine of common purpose comes in, and it seeks to address this very same question. I'm going to reflect on case law in this regard, starting with the case of NUMSA on behalf of Operate Dludlu. That's the case I referred to against Mali Pipe Systems. In that particular case, the Labour Appeal Court recently dealt with the concept of common purpose. And this was a dispute about wages. On the 14th of July of 2017, the employees embarked on a strike. And during that strike, the head of HR was assaulted. And I think at this point, it is important to take a moment to appreciate all HR practitioners who are part of this webinar. And sincerely speaking, I sometimes feel that the demands and pressures that comes with that function are sometimes undervalued. Now, coming back to the facts of that case, the Mali Pipes case, the employer alleged that the employees assaulted the head of HR. The employer also alleged that the employees acted with common purpose. 148 employees were charged and dismissed. And the decision to dismiss those particular employees was tested at the Labour Court and subsequently the Labour Appeals Court. The employer presented photographic and video evidence. Video footage showed striking employees celebrating and chanting after the assault has ended. 12 employees were identified in the assault, but about 136 employees could not be directly identified. Now, the Labour Court found that the rest of the 136 employees were equally guilty, and they were relying on the doctrine of common purpose. The Labour Court said those employees who were identified as being on site that day acted with common purpose because they associated themselves with the events of the day. The employees were not happy and they appealed that particular judgment, and then it went to the Labour Appeals Court, which agreed with the Labour Court. And let's quickly explore the reasons given by the Labour Appeals Court. The court considered the Constitutional Court judgment in Dunlop, which said evidence must show that the employees associated themselves with the violence before or after it ended. This is quite important. You will recall in the facts of the Mali Pipes case, they say that after the assault ended against the head of HR, they were chanting and celebrations. Now, Dunlop says employees may be dismissed for hatching the plan, implementing the plan, or celebrating the execution of the plan. So the misconduct could be direct or indirect. As long as the employer can show that the employees knew of the conduct and intended to be associated with it, it is important, however, to note that there must be a link, some form of identification that links the employees to the misconduct. And coming back to this case, the Mali Pipes case, the Labour Appeals Court said the doctrine of common purpose, and I want to quote what the Labour Appeals Court said. It says it allows an employee to be held to account for collective misconduct where the employee associated with the actions of the group before or after the misconduct, even if not present on the scene where the employee had prior or subsequent knowledge of the misconduct and he or she held the necessary intention in relation to it, close quote. Now, one might ask, how then do you determine this? Now, in Mali Pipes, the case, the Labour Appeals Court said, the questions that one must ask is, was the employee present at the scene? Was the employee a bystander? Did the employee take steps to distance themselves from those events? Did they explain their involvement in relation to the misconduct? So those are some of the questions that you will need to ask yourself as an employer in determining whether there is that nexus. Now, this takes us to the next topic that I'm dealing with, which is misconduct during civil unrest. And I'm sure we all can recall the events that took place during June and July of this year, which was a dark period in our country. The civil unrest that started in some parts of KwaZulu-Natal and spread throughout the country, and it presented new challenges for the employer. And I'm sure some of us will recall the young man was caught on several videos leaving a Woolworths store with a basket of food and putting that basket of food into a Mercedes-Benz that just happened to look like Adil's Mercedes-Benz, but I'm not there. He told the media that he picked a basket of food on the pavement. Now, indulge me for a second. Having learned from the Mali Pipes, do we really think that his defense will hold water? He says, no, I picked up the basket of food on the pavement and I took it to my car. Now, according to his version, he was not part of the distraction. According to his version, he grabbed a basket of food on the side of the road and left. And I will argue that by taking that basket, he associated himself with the conduct of that day. And as a result, he would have been found guilty based on the doctrine of common purpose if we were to apply Mali Pipes. Now, coming back to the issue of civil unrest and employment relations, and the question is, may an employer dismiss an employee for participating in civil unrest? Generally, what an employee does outside working hours is of no significance to the employment relationship. However, what is called, often referred to as off-duty misconduct, can in certain circumstances constitute a valid reason for disciplinary action, resulting in a sanction as serious as a dismissal, especially if the conduct constitutes a criminal offense and where the nature of the conduct results in the destruction of the trust relationship. Now, let us consider the code of good practice as to what does it say in this regard. And I want to quote from the code of good practice. It says, the contravention of a rule regulating conduct in the workplace or of relevance to the workplace is capable of being the subject of a disciplinary action, end quote. The key words here are of relevance to the workplace. Therefore, the off-duty misconduct may result in a disciplinary action as it may be deemed of relevance to the workplace. Now, the question is, how do we determine whether that conduct is of relevance to the workplace? There must be a link between the employee's conduct and the employer's business. To prove this nexus, the employer must think, is the link between the conduct complained of, for example, the looting, the violence, and so on, the employee's duties and or position that they occupy within the company, the employer's business or the workplace. Consider the employer's profitability as well, continuity of the good name and reputation of the employer. Now, does the employer have sufficient interest in the conduct? That's what the employer needs to ask itself. And if the answer is yes to all these questions, it can result in disciplinary action. Now, let us look at what one case had to say in this regard, and I'm looking at the case of FISA versus Woolworths. And in this particular case, the employee was arrested on a charge of theft from a department store owned by a competitor of the employer. Before she was convicted, the employer dismissed that employee due to her arrest on grounds that she had a number of subordinates who were expected to look up to her and that she could no longer be trusted. The commissioner held that the employer is entitled to take disciplinary action against the employee for conduct off the premises and outside working hours. The commissioner further held that the employer was not obliged to wait for the conclusion of criminal proceedings against the employee before taking such disciplinary action. Now, the last issue that I'm going to look at is whether can incarceration constitute incapacity. Now, we've seen that you can be dismissed for off-duty misconduct where you are arrested and so on, but now we're looking at it from an incapacity perspective. It's important to point out upfront that incapacity is not limited to poor work performance, ill health or injury, and accordingly, incarceration may constitute incapacity. And to this end, one has to look at the Labour Appeals Court decision in the case of Soman Kotubatse, Ferrochrome against the Metal Industries Bargaining Council. The employee was arrested and incarcerated on suspicion of having committed an armed robbery. 10 days after his arrest, he received a letter informing him that he had been dismissed for incapacity. The employee remained in custody for approximately 5 months. After being found not guilty and being released, he referred an unfair dismissal dispute to the relevant bargaining council. At the bargaining council, the commissioner ruled that his dismissal was procedurally and substantively unfair, and that award was taken to the Labour Court for review. The Labour Court's view, it says the true reason for the employee's dismissal was misconduct for unauthorized absenteeism and not incapacity. Now, this was appealed, and this is the important part. The Labour Appeals Court found in favor of the employer and holding that the definition of incapacity was wider than that was asserted by the Labour Court. And it basically explained it in this way, and I quote, it says incapacity may be permanent or temporary and may have either a partial or complete impact on the employee's ability to perform their job. The Code of Good Conduct dismissal conceives of incapacity as ill health or injury, but it can take other forms. Imprisonment and military call-up, for instance, incapacitate the employee from performing his obligations under the contract. And taking that into account that the employee was incarcerated for 5 months, applying that particular principle, the Labour Appeals Court found in favor of the employer in terms of incapacity, and this was confirmed subsequently by the Supreme Court of Appeal. So I will end my presentation with that particular case, and I will be handing over to my colleague Bongani Masugu, who will present the next session.
Thanks very much, Tabang. Good day to everybody. I'm going to just share my presentation with you. So can I just get confirmation you can see my slides?
Yes.
Yes, we can. Thank you very much. Now, I'm going to speak to you about the payment of bonuses to non-striking employees. I'm going to speak a little bit about organizational rights, what they are, and who may exercise them. And I'm going to speak to you about the role of political parties in the employment arena, if any. To begin with, does the payment of bonuses to non-striking employees by an employer amount to unfair discrimination in terms of any of the legislative pieces that govern employment law? Does it curtail the right to strike, perhaps, or could that be one of the consequences of the application of that bonus incentive scheme? This was the question that was to be determined by the Labour Appeal Court in NUM versus Cullinan Diamond Mine, a division of Petra Diamonds Pty Ltd. And in that case, very briefly, there were wage negotiations between the NUM and the employer, the mine. These deadlocked and a protected strike ensued, which lasted for a period of about 12 days. While the protected strike was going on, about 30% of the workforce, some of which included some NUM members who had decided not to participate in the strike, continued pushing production. About 52% of production was able to be achieved in the 12-day period while the others were out on strike, and the employer decided that it was going to reward those employees for what it considered to be exceptional performance during trying times when everybody else was out on strike. And they, instead of applying the normal annual production bonus that the employer had in place, applied something different. So they said, we are not going to reward employees with the normal annual production bonus, but we are going to reward the group of employees that have actually been at the workplace while the strike was ongoing and that have pushed production up to about 52%, which of course was considered to be quite exceptional. And the question then that arose for determination when the matter arrived at the Labour Appeal Court, because then after the payment of that exceptional performance reward or bonus to those employees who had not participated in the strike, the NUM felt aggrieved for its members and referred a dispute to the CCMA, claiming that the payment of the exceptional performance bonus to a section of their workforce that had participated in work while the strike was ongoing, and the non-payment of that to those that actually participated in the strike and did not work during that period constituted unfair discrimination, both in terms of Section 6 of the Employment Equity Act, as well as in terms of Section 5 and Section 10 of the Labour Relations Act. The referral was conciliated and unsuccessfully conciliated at the CCMA, then referred to the Labour Court. The Labour Court decided the matter in favour of the employer, saying that that payment of the exceptional performance bonus was not discriminatory as contemplated in the Employment Equity Act and the Labour Relations Act. The NUM was still unhappy and referred the matter on appeal to the Labour Appeal Court. The questions for determination before the Labour Appeal Court were whether Section 6 of the Employment Equity Act was breached by the implementation of the exceptional performance reward bonus and the payment thereof to non-strikers. The other question was whether Section 5 of the Labour Relations Act, which prohibits the any conduct on the part of the employer, the effect of which is to punish an employee for exercising any right that is conferred on them in terms of that act. The question for the Labour Appeal Court was whether Section 5 had been breached. In other words, does the payment of the exceptional performance reward or bonus to non-striking employees breach or violate Section 5? Because the employees that had participated in the strike were of course exercising a right in terms of the Labour Relations Act. And the argument from the NUM's point of view was that that payment or non-payment to striking employees was a punishment to those employees for them having exercised that right to strike. The other issue for determination was, of course, whether in terms of Section 10 of the Labour Relations Act, or the onus in such discrimination cases rests on. In deciding the issue on the facts of the case, the Labour Appeal Court found that there was no prohibition in the Labour Relations Act or in the Employment Equity Act for an employer rewarding non-striking employees for extra or exceptional work that they've performed or extra or exceptional performance that they have given to the employer. On the facts of the case, the Labour Appeal Court found, much like the Labour Court had found, that there was no causal nexus between the act of striking or the act of participating in the strike and the non-payment of the exceptional performance reward. In this regard, the Labour Appeal Court considered whether there is another reason which might be the true reason for the payment of the exceptional performance reward to employees who had actually continued with production outside of the fact that they didn't participate in the strike. And in deciding that issue on the facts, the Labour Appeal Court found that the reasons proffered by the employer for rewarding the exceptional performance of those employees that had actually continued with work while the others were on strike was sufficient reason to prove that the strike or the act of participating in the strike for the other group of employees was not the sole or the main motivator for the employer to reward the others that were not striking. The only warning that comes out of that judgment is that employers must be careful when they consider implementing performance bonuses or performance rewards, or indeed exceptional performance rewards such as these bonuses in relation to employees who participate in work and push production while others are out on strike. they must be careful to ensure that that is not an indirect punishment and that sufficient reason exists for you to differentiate those groups of employees and that you apply that bonus according to methods that are not discriminatory in nature. The next important thing to consider under the topic of the payment of bonuses to non-striking employees is, of course, the other judgment of the Labour Court in NUM versus Element 6 Production, P2R Ltd, where the following quotation, I read exactly from the quote, is stated by the Labour Court. There's nothing in the Labour Relations Act or any other statutory provision that prohibits an employer from utilizing the services of its non-striking employees to perform work ordinarily performed by striking employees and for rewarding them for going the extra mile in doing so. And with those comments, I think it is quite clear that from at least the Labour Court and the Labour Appeal Courts and the case law point of view, nothing will stop an employer from implementing an exceptional performance bonus, provided that you have sufficient reason for doing so and that that reason is not a breach of any of the sections that were interplaying in the NUM versus Cullen and Diamond Mine case. Next topic I will cover as quickly as possible with you is the issue of organizational rights. What are organizational rights and who is entitled to exercise organizational rights? Organizational rights are ordinarily those rights that the Labour Relations Act in Section 11 confers on representative trade unions. They include, for example, the right to access to the to an employer's workplace by trade union officials and members, the right to deduct trade union dues or subscriptions and levies, which is in Section 13, the right to trade union representation in the workplace, so where there's an issue or dispute in the workplace, disciplinary inquiries, grievances, and the like. Trade union members who may be shop stewards have a right to represent employees in that setting, in that forum. There is also a right in Section 15 to take leave for trade union, either shop stewards or officials, so that they can attend to trade union activities. And there's also a right that applies to the trade union organizations in general to have access to certain information or to request the disclosure of certain information. Now, who may exercise these organizational rights? As I've already alluded to at the beginning of this section, Section 11 of the Labour Relations Act defines a representative trade union as a trade union, so one trade union or a number of trade unions acting jointly, who have as their members a sufficiently representative number of employees employed by the employer in the workplace. Those trade unions which meet the definition of representative trade union are the ones upon whom these organizational rights are conferred. If that is the case, what then is the role of political parties in the workplace, and particularly in relation to the exercise of any of these organizational rights? The definition of the representative trade union in Section 11 ordinarily, automatically, I should say, excludes political parties from enjoying those organizational rights. While representative trade unions are a union or a number of unions acting jointly, whose members are sufficiently representative of the employees in the workplace of an employer, that definition does not fit a political party. And for that reason, political parties would ordinarily be automatically barred from exercising organizational rights. What is important to note is that in terms of the Regulation of Gatherings Act, there are certain, call it pickets, call it demonstrations, that political parties may be entitled to organize. And those are in the specific circumstances of the application of that act and the rights that are conferred on those parties or those organizations by that act. But these certainly do not extend to picketing in the workplace. Some of the important things to take into account from the Regulation of Gatherings Act is the right to convene a gathering is limited to a particular organization or organizations. The place where such a gathering may be organized for includes public roads, includes public spaces and public premises, but does not specifically identify workplaces as being one of those places where political parties, for example, may organize such gatherings. There is also a specific procedure for political parties to undertake those gatherings and those demonstrations in these public areas. And for these reasons, political parties have no locus standi in the workplace, and this was found by the Labour Court in Calgan Lounge Pty Ltd versus National Union of Furniture and Allied Workers of South Africa and others, which is a Labour Court judgment. The other important judgment to take into account in this regard is Lang Plus, Border ACC and others versus Machini, where the Labour Court, and I quote, had the following to say: being a political party, and to the extent that the EFF, this is a matter where the EFF was involved and had gotten involved in a strike that was undertaken by the employees of the employer, Lange Plus Border in this case. And the Labour Court had the following to say: being a political party, the EFF was of the view that it needed to assist the farm workers. Its role, in the light of the employees being not unionized, ought to have been limited to an advisory one, and not an interference in the litigation process between employers and their employer. Thank you. Those are the brief topics that I wanted to cover in 7 minutes.
Thanks very much, Bongani, and your selection of cases has been appreciated in the chat feature, and likewise, Tabang, the issues that you've discussed. It's clear that there's a lot of interest in respect of the incapacity dimensions, and it's perhaps something to consider a future session on. Hugo, thanks to you and your team. There was a question on strike ballots that I'm going to ask you and your team to deal with on the chat down the line. And I think your reference to golf clubs has got a lot of people thinking about the weekend. So thanks very much for those presentations. Our second panel discussion will be moderated by Andy Besadenhout. The focus is on protecting privacy and confidentiality in the midst of the remote working environment, as well as on the impact of POPI and RICA. In addition, cross-border transfer of information has become crucial, also as a result of the increased mobility of the skilled workforce. CDH's work in this space has been bolstered with partnerships, as you heard Adil say this morning, with experts based in various parts of the world. And I'm going to ask Andy to introduce the speakers in her panel and to explain further.
Thank you, Avinash. I am privileged to introduce two speakers this morning. The first is Stephanie Creed, who's an associate at Bird & Bird based in London, as well as a partner, Shem Mutanga, who is based in Nairobi, Kenya. And our session will be focusing on the processing of information and specifically across borders. And I think just as an introductory remark, from South African perspective, we always feel that it's quite simple, but it really isn't, especially those of us who have been inundated with emails about POPI and POPI coming into effect and us agreeing to the processing of our personal information. But some of the things that we need to discuss and consider from an employment law perspective is that a lot of this information is in fact crossing borders and going into other jurisdictions where more than just POPI applies. So Stephanie has been providing strategic and practical solutions for a wide range of contentious issues from an employment law perspective, and she's also developed a particular expertise in advising on data protection matters touching on the HR sphere. And Shem is in our technology, media and telecommunications team, and I'm very excited to be speaking to both of them today. And I think just as an introduction, I'll hand over to each of them to just give us an overview of the processing of information and the impact that may have on remote work, although I know that's a very broad question to start with.
Stephanie, over to you. Oh, I'll go first then. So what we're seeing is that over the sort of last couple of decades, there's been a push towards creation of and collection of processing of more and more data, both in terms of people doing their jobs normally, but actually also in relation to managing employees, working out what they're going to do, making sure that they are progressing, that you're tracking progress, and you can see what people are doing and when. And there's a greater impact as well in terms of analysing the data that's collected. And all of that is sort of adds to the level of risk that an employer has to deal with, because of course the more data you have, the more risk, particularly as legislation develops and the sanctions, as we've seen in Europe, become significantly more serious. In terms of how that works in the remote working space, I think what it's fair to say is we've seen an increase in activities like employee monitoring, collection of data as to what people are doing, keeping an eye in, and the growth of new technologies around monitoring what people are doing, keeping an eye on, making sure that data is secure, working out if you need to put in additional boundaries. And of course, all of that then ups the level of risk in terms of what data is being collected and processed, but also exposes employers to a bigger risk in terms of there's potentially more gaps because you can't see what people are doing on the ground. So you're having to rely on technical solutions to protect your data, your assets, but also trying to find that tricky balance with confidentiality and privacy, particularly when people are working from home and you're getting a window into their private life. You might see their kids running around in the background, and actually that creates a whole host of new issues that employers have never really had to think about, and certainly not in any great detail. Now that's becoming a daily consideration. Shem, is that a good point to sort of, I can see you nodding, is that a good point for you to sort of step in and add what you might think?
Shem is on mute.
Apologies for that. Yeah, I agree exactly with what Stephanie has been saying, particularly the point regarding the balance between monitoring and the employer's legitimate interest to track employee performance in the remote working environment versus the right to privacy. And there's a delicate balance there, because the right to privacy is a constitutional, a fundamental freedom under the Constitution, and of course it carries constitutional weight, and that tends and in the hierarchy of our laws.
We've lost him for a moment.
Stephanie,
yes, there we go. You're back.
Sorry about the intermittent connection. So I was just saying that there's that tricky balance, and there's a delicate balance that needs to be observed whenever you're monitoring, and I guess I'll say a little bit about this in the course of our discussions. But principles like data minimization, really come into play in demonstrating that you're not crossing the boundary of the right to privacy, and you're only getting that information that you really need to monitor your employees and ensure productivity, which is in the interest of your business as an employer. So that point I really do agree with Stephanie.
I think just from the question we get asked quite often is, where does the boundary lie? And I guess that's a very difficult question to ask, but I would be interested to know in relation to your jurisdictions. So for example, if I'm an employer and I've issued my employees with internet connection and a laptop and they're all working from home, what would be my rights generally in relation to monitoring what they're doing? But more than that, how much do I need to tell them? Am I going to monitor up front? Or is it a case of I've issued the infrastructure and I have the right to assess?
So the concept of employee monitoring isn't new. I think that's probably worth stating at the outset. This isn't something that's come about just because of the pandemic, but it is becoming much more of a forefront issue. And what is new is the extent to which electronic methods of monitoring and surveillance are being used. And that's putting it firmly in sort of the crosshairs of data protection legislation. At the most basic level, employee monitoring covers any activity involving surveillance, supervision, observation of staff members. So it's pretty broad, and it comes in a lot of different forms. It could be monitoring email content, internet use, CCTV surveillance if we're physically in an office. Not so many of us are at the moment. But there are other forms, things like keystroke monitoring, location tracking. And actually what we're seeing more of is things like facial recognition technology, video technology being used to check that people are at their remote desks. And what they're doing is it's sort of taking snapshots every couple of seconds to check they're still sitting there. We're also seeing lots of technical solutions for employees. There are tools that you can use to make sure your mouse moves every couple of seconds to get around keystroke monitoring. So there is a bit of a cat and mouse game going on there. I think firstly, in terms of working out what you can do, it's worth looking at why you are monitoring someone. Now, it might be driven by concerns about risks and potential damage, so data loss, disclosure of confidential information, and that might well be legitimate. It might be damage to the brand or loss of business. It may be actually that there's a slightly more Orwellian design going on, that actually you want to look at exactly what people are doing and check that they're exactly doing what you think they're doing, in the way that you might look over an employee's shoulder in the office and you can see their screen is busy, so you can see that they're doing things. But it may also be actually it's more about working out whether efficiencies in the building or in the office, are there people who are not that active? It could be in the context of disciplinary grievance performance reviewing and other perspectives. So it's worth, as a starting point, working out what you're doing and why, because that's going to define whether it's reasonable to then carry out the monitoring. Because what's key to all of this and whether it's reasonable is what's the purpose, and then how does the monitoring that you're proposing tackle the problem or the concern that you are trying to get to. Beyond that, there are a couple of sort of general principles to be considering. You've obviously got to, in the UK, comply with the UK GDPR, which comes from EU law, even though we're no longer in the EU. That's a lovely complication. But also domestic legislation. I'd love to say that Europe as a whole is now completely homogenised. We all have the same law. We don't. And actually, there's still quite a lot of local variation. And what you will need to do, certainly in the UK, is work out what your legal basis is and make sure that your compliance pieces are in place, particularly for something as high risk as employee monitoring. Because if you get that compliance piece wrong, you're automatically in a place where the sanctions are going to be quite significant. It's worth saying that you have to inform staff as to what you're doing. You have to have appropriate policies in place and you have to let people know. Partly that's because of the compliance piece we've talked about. People have to be told what monitoring will be carried out, what the data will be collected, why it will be collected, what will be done with it. That's under sort of Articles 13, 14 GDPR. That's a compliance piece. There is also the employment piece of trust and confidence. If you start doing things that undermine that mutual duty that exists in UK law of trust and confidence, you actually start creating grounds for employees to resign and bring claims. So it's quite important on both sides. There are certain exceptions. Covert recording and monitoring is acceptable, but it's only going to be in really narrow circumstances. And that is almost certainly not going to apply unless you're looking at things like potential criminal activity. It's really quite significant, and it has to be where you've got a reasonable suspicion of something going on. There are sort of practical employee relations issues with how you communicate. Funny enough, employees don't like being monitored, and if you tell them, you have to think about how you're going to tell people in order to minimise the potential risk of claims and everything of that relation. There are ongoing issues in terms of access and retention, what you're going to do with the data, how you're going to, who you're going to have access. And there is also the ongoing, and I think it's becoming a bigger issue, Shem, I'm sure you're seeing the same, in terms of where the boundary between private and personal ends and where public or work-placed or related communications starts, particularly with technology like WhatsApp and other messaging services that people routinely use for work, but aren't necessarily controlled by or operated by the employer. And that's certainly becoming a problem in the UK in terms of investigations. Shem, I don't know, is the position different in your jurisdiction?
No, I mean, it's quite similar. The Kenyan Data Protection Act borrows quite heavily from the General Data Protection Regulation in the EU, and we have an act for borrowing laws from other countries here in Kenya. Our constitution is quite similar to the South African one. A bit of laziness, perhaps. Don't quote me on this on the drafters end, but it's kind of useful because then we get to borrow from the jurisprudence that's being developed in other jurisdictions. So a lot of the points that you've mentioned apply here as well. Employers can monitor employees. but the requirements for proper notice and transparency do apply. Lawfulness, fairness, and transparency in the processing of data is a principle that is replicated under the Data Protection Act in Kenya as well. So you definitely also need to have a lawful ground for processing personal data in the respect of remote working monitoring. So legitimate interest would be a useful ground, but employees can also consent upon being notified that they are actually being monitored. But under our law, consent can always be withdrawn, and at which point processing needs to be terminated. So having an extra ground is useful. Data minimization is another principle, and you mentioned purpose. Having a proper why for what you're doing is critical. So whatever processing occurs in the course of monitoring employees who are working remotely, that needs to be adequate. It needs to be, relevant and necessary. You need to demonstrate that it actually serves the purpose of the employer, and it's not just the employer being a busybody, for example. But I also want to add that under our Act, there's a requirement for data processing impact assessment to be carried out whenever there's processing is likely to result in a high risk to the rights and freedoms of the data subject. So this, I believe, because of that gray area, particularly between what's work and what's personal, and that gray area about what where you cross over the line into infringing the employee's privacy rights, I think a data protection impact assessment would need to be conducted. The Data Commissioner has released guidelines on how to go about doing this, but practically speaking, a lot of awareness still needs to be built, and competencies also built among data protection officers, etc., as to how to properly conduct this. So I think those are relevant in the context of employee monitoring from our perspective.
So both of you have touched on this, which I think is an incredibly important principle, purpose. So there must be a purpose for monitoring. We can't start monitoring employees without limitation, and we need to have a reason for monitoring. And I know, especially from a South African perspective, the advice is always that the purpose must be specific. So the recommendation is that you make sure your POPI clause and your contracts of employment are detailed, or alternatively that at the very least your POPI policies are detailed. In your respective jurisdictions, should you find yourself in a position because of the change in time, so in other words, none of us anticipated being in this position 2 years ago, all of a sudden your necessary privacy policies doesn't necessarily provide for everything you would want to monitor. Does that limit your employer's rights to monitor for these new purposes? And what impact does that have? Does that require them to revisit contracts or revisit policies, especially in light of the fact that many of our audience are part of international organizations? So is there a need to start revisiting what are we doing across borders at this point, which we may have not anticipated doing a year or two ago?
I think that's certainly the case. The way we would normally structure it in the UK is to have very little in the employment contract itself, because you need employee consent to change it, but to put the detail into your policies, which you don't need employee consent for. But actually the advice should be always to sort of keep that policy under review and actually to update it regularly, because what you can do is governed to a large extent, or the safety and the level of risk in terms of what you want to do will be governed by the policy and what you've told employees you're going to be doing. So it's important, if you want to start carrying out additional monitoring activities, that you make sure your policies reflect what you're doing, because at least then, if the ICO turns up, if there's an employee complaint, the Information Commissioner will always ask, what does your policy say? And you're in a much better position if your policy says we're going to do this type of monitoring for these reasons, than if it's completely silent, because at that point you've got a compliance failure. The same is true, Shem's mentioned DPIAs. It's the same in the UK, that you have to have a DPIA for high risk activities, anything involving lots of personal data, for example, being processed. And it's again important to keep that updated for exactly the same reasons. What you've got to be able to show is it's not only a question of being compliant and doing the right thing. You might be collecting data for entirely all the right reasons, but the GDPR also requires you to be able to show that you're complying. And that means that you've got to have this documentation in place. And that's the quickest and easiest way to make sure that all employees know what's going on, but also so that you're covered from a compliance perspective, is updating that policy and making sure that it's clear and it's up to date as to what you're doing and, if needed, why you're doing it, that explanation. I think the other piece to it is thinking about the employee communications and thinking about how you're going to communicate this to employees, particularly in circumstances where people might think that it looks like snooping, because it's one thing to have a risk of a claim, it's another thing for an employee to be disgruntled. It's the disgruntled employees every time that are going to bring the claim. So there's a practical aspect to it as well in terms of how you're going to roll this out. Yeah. Is that sort of similar?
Yes. Yeah, and Shem, in your jurisdiction, is it fairly similar?
Yeah, absolutely. Exactly the same as what we're discussing right now, and perhaps just to add, the requirement under the principle is for purposes to be explicitly specified and legitimate, and not further processed in a manner that is incompatible with those purposes that have been specified. So you can have your purposes set out in your policy, and to the extent that any new purposes for which you process a personal data cannot be clearly demonstrated to be inconsistent with those purposes, even though they're not 100% set out in the express wording, there is flexibility, to say that, hey, this is incidental to the clear, explicit specified purpose, and therefore it's not out of line. So you need not list all 1,000 things that you would do with the personal data, but you need the emphasis is on the data subject to be very clear as to the main purposes for which you will handle their data. So to the extent that there is no reasonably non-incidental purpose or another incompatible purpose, then you pretty much be in the clear. But I do agree with the point that has been made about not including this in the employment contract, because you'd require consent to amend that, and having that set out in your policy, which you as an employer can freely amend and just give notice and upon consultation with employees. But ultimately, it's the employer's discretion to really amend the policy.
It's probably worth just flagging that consent wouldn't be a basis in most circumstances for processing data in the UK and across Europe, because of the view taken as regards consent to be valid has to be freely given, and almost all of the European data protection authorities have said it can't be freely given in the employment relationship. It just doesn't work because your employer says jump and you say how high. So it's worth sort of, in the UK certainly it has to work on the basis of another legitimate ground for processing, which can make things more straightforward in some ways, but can add to the complications.
I think my last question is going to go to one of the questions that's been raised as well, or a similar topic, is we're all in a situation where our jurisdictions and our employers are all considering vaccination status and requiring that disclosure. And I'd be interested to know, in your organizations, what are the requirements generally? Should an employer be of the view, especially if they would want to process that information locally and then send it over to a head office, which may be in a different jurisdiction, about vaccination status specifically? Do you need consent to obtain that from your employees, and what can you do with that information if you obtain it?
Shem, do you want to go first on this one?
Vaccination, it's been a source of some controversy locally.
Some
controversy.
A little bit.
Just a little bit. There was a circular that leaked to the media a couple of weeks back that had supposedly been circulated by the head of civil service to all public servants, indicating that they would be required to be mandatorily vaccinated, failing which they would be exposed. They would have to face disciplinary action, right? So, of course, it was not published. It was an internal circular, but media, being the media, got a hand of it, got a hold of it, and it leaked, and a report was published. So the president had to step in because everyone was up in arms saying this is a violation of our constitutional rights to freedom of opinion, freedom of conscience, freedom of belief and religion for some people, and the president had to clarify that no mandatory vaccinations would occur. And in any event, under the Employment Act, disciplinary action can only be taken on set grounds: poor performance, misconduct, or incapacity. So refusing to take a vaccine would not constitute a ground for disciplinary action. So that has been shelved for the moment, but the general view is that the government will continue to push for vaccinations to occur. The employer does have an obligation to provide an environment for the employees within the workspace, within the workplace rather, that is safe, that is advances their welfare and their health. And it could be argued that requiring employees to get vaccinated is part of that duty, because employees who are not vaccinated and who come into the workspace could contract the virus and God forbid could get very ill, and in many cases, as we have seen, a lot of people have passed away. So there's an argument there that requiring employees to be vaccinated before they come to the office is part of that duty. But the most you can do is prevent them from coming to the office, and that might, some employees might love that they don't have to come into the office ever again, and that probably isn't something that you'd want as an employer. So there's a tricky situation there. But currently, what most employers are doing is having vaccination drives, inviting the Ministry of Health to their offices, trying to build awareness about the safety of the vaccines, about the importance of the vaccines, about the threat of the disease, and ultimately it still is up to the employee as to whether they want to take the vaccine or not. There's no policy currently regarding mandatory vaccinations. Under the Data Protection Act, information about a data subject's health status would constitute sensitive personal data, which can only be processed in very limited circumstances, right? One of which would be to enable a data controller to discharge their legal obligations. So going back to what I mentioned about the Occupational Safety and Health Act, if you argue that I'm under legal obligation to provide a healthy environment for you, it might be necessary for me to get that information. So you can get that information from your employee.
Yeah.
Sorry.
No, apologies.
Yeah, and our Data Protection Act has, well, again, an error in drafting in my view, because it goes further to provide an even higher threshold for processing of health-related data, in saying that it can only be processed by a medical professional or by an individual who is under a professional obligation to maintain secrecy. So very few employers, of course, fall under that category if you're to interpret that provision very strictly, right? Which means you can never then ask for health data from your employee if you don't fall within those categories. And that's problematic because you might need that health data for your insurance, employee insurance, which is a statutory right under the Employment Act locally. So that for me is a provision that needs to be amended to give clarity. The Act is fairly new, so no amendments yet. But basically that is the general environment around vaccines at the moment.
Thank you, Shem. And then just in conclusion, Stephanie, I'd like to hear from you as well about vaccination status and what employers can do, and then we'll hand back to Avinash.
No problem. It's not dissimilar actually to what Shem's described. The UK government there have been various noises made about possible mandation of vaccines, but actually at the moment there's such a pushback in the UK around the idea of a mandatory vaccine that it hasn't gone anywhere. We've got legislation for requiring care home workers, for example, to be vaccinated, but actually the government doesn't have the power to force someone to be vaccinated. It can just simply state you can't work in this environment if you aren't vaccinated. It is possible in the UK to ask for vaccine status information, but only if it's proportionate and necessary for employers to comply with their legal obligations, primarily to ensure the health and safety of their workplace. And in a lot of cases, this is difficult for employers to demonstrate. What we're seeing is the ICO guidance that we have, that's our information commissioner, states that data protection law doesn't prevent employers from taking steps to keep people safe, but there still has to be compliance with the GDPR, and actually it's this purpose. Why do you need the vaccination information? And is there anything that's less intrusive that you could do that would get you to the same state? And of course the problem with that is always if you've got social distancing measures, you've got masks, hand washing and all of those kinds of steps, do you really need someone's vaccination status? What we're seeing with a number of employers is actually they are saying that you can only come in if you have either had a negative test within a certain period of time before coming into the office, or you've been vaccinated, and they're requiring employees to attest that they are eligible based on the eligibility criteria to try and minimise the amount of health data they're collecting, but also protect employees who are in the office and make sure that they're covered from an insurance perspective. Because there's always going to be, as Shen's alluded to, there's always going to be that tension between insurers wanting to sort of making sure that you're covered for insurance purposes, but also making sure that you're not collecting too much data that you're exposing yourself to a risk. It does depend on the sector, it does depend on the role, and it depends on the kind of working environment you're in. There are certainly some sectors where it will be much more acceptable to ask about vaccine status and to be quite upfront about have you been vaccinated, in which case have you been tested. But we're seeing a much more of a reliance on testing as an alternative in order to get around some of the direct and indirect discrimination risks of dealing with people who are not vaccinated and asking for that information or excluding them from the workplace on the basis of their vaccination status, which is, there's a potential risk, but there is also the actual practical sensitivity, vaccines being such a sensitive topic in the UK, the attempt to try and exclude people based on vaccine status alone, there's probably a bigger PR risk than there is any other risk at the moment, given how sensitive that is.
I wish we had more time because it's just such an interesting topic, and I think the more time goes by, the more information we would all want to process and all need to process in an employment field. But I thank you for both of you for your time this afternoon, and we really appreciate it. And I'm going to hand over back to Avinash.
Yes, and thank you to you, Anli, for moderating that really important and interesting session. It just shows that the context may be different, but the challenges somehow transcend borders and they remain the same. So it's always good to hear what's happening in other spaces for our own development. Our final substantive session considers the controversial issues of discrimination, religion and cultural identity in the next normal, also linking this to mandatory vaccination and unfair discrimination, which is some of the questions you've been asking in the chat feature as well. Fiona Lepan and Pateni Nkuna will consider the new obligations on employers, as well as the limits of an employer's power to regulate religious practices and the like in the workplace. Over to you, Fiona.
Thank you very much to you all. And this is indeed an intriguing topic, and one where I will also be touching on some very recent case law from the European Court of Justice, which I will juxtapose against our constitutional court's ruling in quite a number of important decisions that talk to these aspects. So my starting point is, as we move towards a new normal and a hybrid model with regard to work practices, we will have probably noticed that employees are perhaps endorsing their religious, their cultural norms, specifically as a consequence of suffering devastating impact caused by this COVID pandemic, where they've lost family members and close friends and work colleagues. And where they've been working largely from home and being able to express their religious and cultural norms more freely, will they wish to bring that to the workplace? And will that create any difficulties for employers? And what would be the role of the employer in this new norm? So as a starting point, we must accept that religion and the adherence to cultural norms is central to the lives of many. And these are underpinned, of course, by our own constitution, which recognizes the right to freedom of religion, to cultural adherences, to even political affiliation. But our constitution's preamble starts with a very important statement, and that is that South Africa belongs to all who live in it and united as they are in their diversity. And our Constitutional Court has expressed that diversity is the hallmark of a free and an open society, and that recognition must be given to the inherent dignity of all people. Now, when one looks at these various different freedoms, and we've heard this morning that these rights are certainly not without some degree of limitation, we're going to be looking at a balancing act, and it's a balance between the right to the freedom that's being expressed, to the relevant rights of co-workers, and 3, the commercial interests of the workplace. So how do these rights, what do they encompass? Well, particularly if I look at cultural norms and look at religion, it's the right to hold a belief. It's a right to express that belief publicly and to show or to display that belief through worship or practice. And I want to take us to some of the case law which underpins how our labour courts have dealt with this matter over the last decade or so, because it's going to inform us how we manage our new normal. Importantly, there was a decision some years back involving Rainbow Chicken Farms, and here the employer dismissed its employees who were employed as butchers because they wanted to celebrate the religious event of Eid. They were obviously of Islamic faith, and in fact the employer required that because these particular employees were employed as butchers and they needed to slaughter chickens in accordance with halal standards, and that was laid down, the principles for that laid down by the Muslim Judicial Council. Now, there was an inherent requirement of their jobs that they be of Islamic faith, but the moment they sought to celebrate Eid and be absent on that day, they were dismissed for their absence from work. And our Labour Court took a very strange approach at that time. Its attitude was, well, does it actually matter? If all employees in the organisation right across Rainbow Chickens was required to work on the day of Eid, then these persons were not being discriminated against. But that's a fatuous way of looking at this issue, because it might have been a rule that was consistently applied in the workplace, but it's disadvantaged a particular group of persons because of their religious affiliation. So we didn't have a good starting point to our discrimination law when that matter was decided all those years ago. Why? Because indirect discrimination was clearly not central to the argument that was forthcoming in that case. But if we move to another case of Flamini and others with Green Force Security, well, what was the issue there? The employer had a rule in its workplace that in order to project its image and its professionalism as a security company, its security guards must be clean-shaven or with trimmed beards. This group of employees was disciplined because they wouldn't adhere to that rule. They said that they were belonging to the baptized Nazareth group, and that had a rule, a compulsory rule, that you may not shave or trim a beard. When this matter came before the Labour Court, obviously the employees had to prove that this clean-shaven rule would offend a tenet of their religion, and observance thereof would be compulsory. Now, they led an expert who unfortunately was shattered under cross-examination for the simple reason he could not point to any rules, any source in any books, expert writings, as to this being a compulsory observance, i.e. that to be adhering to the Nazareth group, that you would not be allowed to shave or trim a beard. But it seemed that the other difficulty the employees had is they were selective about their religious observances, because according to them, they had to observe Sundays as a holy day, but chose not to and came to work because they were earning overtime money. And the court said, this isn't acceptable. We can't have a situation where you'll adhere to some rules and not others, and there's no justification for what it is you're seeking to achieve, employees. So the discrimination wasn't proven. But in an important case that went from the Labour Court all the way up to the Supreme Court of Appeals was the POC Crew and Department of Correctional Services decisions. Now, these persons who were dismissed from Pollsmoor Prison were of course prison officers, prison guards, and they refused to cut their dreadlocks in terms of the employer's dress code. So the employer insisted on neatness of hair, and that specified hair length, length of a fringe, hair at collar level, and no hair over the ears. So if you're going to be of Rastafarian faith and wear dreadlocks, then you were you were not observing this particular code, and this led to the disciplinary action taken. 3 out of the 5 employees dismissed were of Rastafarian religion. The other 2 were able to prove that they were wearing dreadlocks because it was a component of them being in training to become traditional healers, and that was something that they wished to do. Now, the employer claimed its policy was a neutral one: cut off the dreadlocks, everyone's wearing hair in the same fashion, and this, of course, impacted the rights of these employees who were put to a disadvantage when this rule was applied to them. Here, if you like, the expert evidence was quite different to the problem that we saw in the earlier case, because one could not doubt the employee's sincerity, and they led the expert evidence that properly demonstrated their religious observances and the rationale for it. But what did the employer have to do then in those circumstances? It had to justify this rule, and these were the justifications that it put up. First, it said, we are nervous that if someone has long dreadlocks, then prisoners can grab hold of that, and this might be the basis for a prison break. The other one was, well, these officers will stand out, and if they stand out, they might be associated with a link to being able to obtain dacha, and should that be brought in for inmates, this might impact security. But no evidence was led for these somewhat bold allegations, which in some instances might even be viewed as laughable. But the rule that they were seeking to impose was having a devastating impact on Rastafarianism and the observance of that faith. So the employer lost the case dramatically because of exactly that attitude it took. It couldn't justify its rule. Now, where the persons were reinstated, it was of interest on another score, because there was a gender-based discrimination at play also, because this issue of having no dreadlocks never impacted the female prison guard who was wearing hair braids or wore long hair. It was tied back. So the rule obviously couldn't stand muster. I'd like to take you to one case which deals specifically with cultural norms, and that's the case of Kivitt's Kruin Country Estate and Monaledi. And the employee had been dismissed on account of her taking sick leave to attend to her cultural and traditional beliefs. She was what was termed in a condition and needed to consult the Sangoma. The Labour Appeal Court went as far as endorsing the decision of the CCMA Commissioner, which found the dismissal to have offended her rights and, more importantly, was unfair, because it said, why didn't the employer endeavour to accommodate her by allowing her to take leave, even if it was for an unpaid period, so that she could attend to her traditional healers course, a very important decision in upholding cultural rights. I then want to take you back a step, just to rainbow chickens and our Islamic employees who were butchers, slaughtering chickens in a particular way, as I had explained. Why didn't the employer endeavour to reach out to those employees and, more importantly, accommodate them in a different way? And it could have done so. One, these employees could have worked extra hours ahead of the celebration of the day of Eid, or even after the celebrations, done the same thing. Even under our Public Holidays Act, an employer is allowed, by agreement with the employees, to swap a religious day for another. In other words, to swap a public holiday out for a different one, so that one can at least observe and give recognition to employees with this particular need. Now, I want now to take you to something that's fascinating, and this is the European Court of Justice decision, which takes the form of a number of recommendations, and it stems from two employers, one in the daycare sector, the other in the retail industry, who were looking to implement a policy of absolute neutrality when it came to religious observances, etc., and the use and wearing of symbology in the workplace. And both coming from Germany was fascinating for me. But in the first case involving Wabe, which was is rather a daycare centre, 3,500 young children in those daycare centres across Germany. The issue was a lady who came to work wearing an Islamic headscarf, repeatedly refused to remove it, and was suspended as a consequence. Another employee wearing a Christian cross faced similar treatment. Now, I want to concentrate specifically on that case and how the European Court of Justice considered these issues, because it said, well, the mere desire of an employer to pursue a policy of neutrality, while itself perhaps a legitimate aim, will not be sufficient. Objectively, there needs to be a genuine need on the part of the employer in order for that rule to be recognised. And what was it dealing with here? It was dealing with parents, it said, that would have a right and would insist on their children being supervised by persons who do not manifest their religion or belief when they're in contact with the children, with the aim of guaranteeing the free and personal development of children as regards religion, belief, and policy. Now, that's all well and good. That's maybe an acceptable norm in that environment. But what the courts went on to look at was to say there needs still to be a justification for such a rule. And it gave some examples of this justification. It said if this was to avoid social conflicts within the undertaking, particularly in view of tensions which might have occurred in the past in relation to political or philosophical or religious beliefs, then perhaps the absolute rule of neutrality can stand. So the recommendation was that the policy of neutrality might well be possible, however, it must be justified. But I want to take you back to a decision of our Constitutional Court, a particularly rich decision, a unanimous judgment of some of our superb jurists over the years in our Constitutional Court. The decision was handed down by Judge Pius Lunga, one of my favourite judges, now unfortunately late, but also Judge Moseneke, and heavyweights in that realm, including Yvonne Nhora, Judge Navsa, Judge Nakabinde, and Noble, and Cato Regan. And this case concerned a school, public school, where the central issue was the dress code for learners, but this has a wider implication for workplaces. And the dress code was no jewellery to be worn of whatsoever nature, and no outward display of your religious preferences and beliefs. And this young pupil wore a very small gold nose stud. And the judgment starts off with Judge Langa saying the controversy that got us to this point starts with an inconspicuous nose stud. And what the judges said in this matter is the wearing of the stud, when it was banned by the school, was a wrong approach. Why wasn't there a proper application for exemption for it to be considered? Because how did this offend in any way teaching at that school? And one of the arguments the school put up is it would erode school uniforms, eventually it would break down standards of discipline in the school, but that was never proven. And what the court said is if there was no fundamental difficulty posed by a young learner embracing her religious beliefs because she was of the South Tamil Hindu religion, then why shouldn't she be allowed to wear it? And listen to what I mentioned with regard to the European Court of Justice. Parents dictating we want a neutral environment for our children so that they do not become confused when they see different religions being portrayed in a public place. Judge Langa said in relation to the Pillay judgment that that doesn't hold any form of water. Why? Because in a culturally rich society such as South Africa, why don't you want children to understand at the earliest stage that diversity is a tenet of our constitution, which should be respected when we deal with different persons in our workplaces who wish to portray their differences, and legitimately so. But, you might add, Fiona, is there no justification you can possibly think of when a rule of neutrality would have to be observed? Well, for those of you that are close to occupational health and safety, you'll find such an example in the general machinery regulations, where no person working in close proximity to moving machinery shall wear or be permitted to wear by the employer or user of machinery concerned loose-fitting outer clothing, any jewellery or ornament, any watch or keychain, any long loose-hanging hair, or anything which may be caught up in moving parts of such machinery. An extreme example, but one that would clearly be of paramount importance where the employer is ensuring the safety of its employees at work. Thank you. I'd now like to hand over to my colleague, Beteni, who has some very useful insights for us with regard to workplace bullying and the new norm and how one's going to deal with issues related thereto. Thank you.
Thank you for that, Fiona. Good afternoon, everyone. I will be speaking on the topic of cyberbullying and vaccinations and discrimination insofar as they relate to the workplace. To kick off what I'll be speaking about, I have a video that I would like us to watch for about a minute. Then I will then get on to the topic of workplace bullying.
Piteni, the audio hasn't come through. You'll need to please reshare with your audio.
Right.
Piteni, still the audio hasn't come through.
Okay, that's fine. I'll just skip the video. The point that was being made in the video is as far back as the year 2015. Workplace bullying cost the American economy at least 1.5 trillion US dollars. That's quite significant when you consider how much money would have gone back to employers as well as employee benefits. Now, drawing this back to the South African context, what is bullying and what is cyberbullying, and how does that relate to the virtual world of work in which we find ourselves today? Last year in October, there was a draft code of good practice on the prevention of violence as well as harassment in the workplace, published in August for public comment, which was open for 60 days. That draft code is really a mirror of Convention 190 of the ILO on the elimination as well as prevention of violence and harassment in the world of work. Now, later on in the conversation, I will deal with what is the world of work insofar as the draft code is concerned, which has moved away from the traditional fixated workplace/work desk. Bullying has been acknowledged in the draft code as a form of violence and harassment, which is now regarded as one word, that is violence and harassment. It is recognized as conduct that undermines human dignity and thus constitutes unfair discrimination. The draft code goes on to consider or define what is bullying. It is persistent or even single conduct which is serious, which also insults, demeans, humiliates, and lowers self-esteem or self-confidence. It also creates a hostile and intimidating environment. I wouldn't be surprised if in the near future, bullying becomes a basis for constructive dismissal claims in the CCMA. The draft code that is, continues to say that this kind of conduct is usually calculated to induce submission by actual or threatened adverse consequences, which also includes the abuse of power. Now, that definition has also been extended to include cyberbullying, which is really the same conduct, just taking over ICT means. That can be via email, via Microsoft Teams. It can also happen via memes or web pages. So all of those are recognized in the draft code. The draft code also recognizes online violence, which again encompasses bullying as well as cyberbullying taking place over ICT means. Now, to make it more interesting, the draft code then moves away from the traditional employer premises definition of a workplace and adopts a much more wider definition or view of what a work environment is. The definition of world of work is a working environment in which persons are in some way or another associated with work. This includes spaces that link workers to the workplace through technology and not just the physical workspace. There's been some comment around that, how the world of work has been defined can actually be extended to include even your private space where you are associated or connected through technology, that is your server, that is your email. and as well as your laptop performing work. So that could be any remote working place that constitutes world of work. Now, the draft code also defines world of work to include commuting to and from home. The scope has been widened to include social gatherings that are related to business, also business travels. So it's quite a wide definition as it stands in the draft code. Clause 7 of the draft code then deals specifically with workplace bullying. It considers the provisions of the Employment Equity Act as well as the Labor Relations Act. Under the Employment Equity Act, we have unfair discrimination, which I already spoke about earlier, that will now be widened to include workplace bullying as a form of unfair discrimination. In relation to the Labor Relations Act, the code makes reference to Section 186 and states that unfair conduct related to promotion, demotion, training, or related to the provision of benefits may be areas of manifestations of workplace bullying. So in essence, what that means is where somebody uses bullying tactics either to deprive you or prejudice you in relation to promotion, demotion, as well as training and the provision of benefits, that becomes a form of unfair labor practice. Now, in relation to the actual bullying, the code then deals with the different types of bullying that can take place in the workplace. Workplace bullying, which is the direct bullying, insulting and demeaning behavior. It then speaks about harassment. It speaks about offending behavior, as well as behavior that is professionally or socially excluding in the workplace. It then speaks about physical bullying, as well as tangible material bullying. This would usually be in the instance where somebody who occupies a higher position uses their power or title to bully a subordinate. It then speaks about verbal bullying as well as passive-aggressive bullying, which could be condescending eye contact, mimicking to ridicule, marginalizing an employee. The code also goes on to provide some interesting examples of what workplace bullying can manifest as. It speaks about deliberately withholding work-related information or supplying incorrect information to sabotage somebody else, as well as compromising somebody else's work or tasks so that they are rated lower in their performance. It also gives an example of supervising or surveilling employees without their knowledge or with the intent to cause them harm, as well as abusing disciplinary proceedings, and also speaks about spreading rumors and recommending that somebody resign. So all of those things, which in some instances could be advising somebody of what their options are, can actually be regarded as workplace bullying. Finally, the draft code then goes on to speak about what an employer's obligations are insofar as workplace bullying. Some of these are in the existing code of good practice. They include having clear policies which make it clear that bullying is a serious form of misconduct and may result in dismissal, to communicate these policies as well as train employees on how they are to be applied, and as well as investigating, which is an obligation already encompassed in the Employment Equity Act, investigating complaints that are brought forward when somebody says, I have been bullied. The next part of my presentation focuses on mandatory vaccinations and unfair discrimination, their intersection. Earlier in the poll, there was a question posed on whether or not your company has implemented a mandatory vaccination policy. When I looked at the results, interestingly, 76% of the delegates said no. The topic of mandatory vaccination has already been dealt with earlier. I will not deal with the intricacies. What I do want to focus on is, when does vaccination or requiring somebody to be vaccinated constitute unfair discrimination, and how do you balance an employee's constitutional rights as well as an employer's obligation or duty to ensure a safe and healthy working environment for its entire staff complement. The Consolidated Occupational Health and Safety Direction of 11 June 2021 had an Annex C, which speaks about instances where an employer has a mandatory vaccination policy in place. In the text of that direction is recognized the constitutional right of employees to bodily integrity, freedom of religion, belief, and opinion, as well as their right to object to mandatory vaccination where they have medical concerns. Now, there have been reports recently on employers finding rather indirect ways to force employees to take the jab. These have included availing certain benefits or privileges only to employees who've been vaccinated, as well as differentiating or excluding employees who've not been vaccinated, incentivizing vaccinations, and in the last week or so, there were talks about vaccination passports. Some of the earlier examples, before the vaccination age group went lower to under 18s, age discrimination was one of the forms of discriminations recognized. That is employees rather who were within a certain age group being the only ones allowed to vaccinate. Now, whilst that was discrimination, so to say, there was justification based on the availability of vaccines and also certain age categories being classified as high risk. There's also been a form of discrimination that is said to be making its way where employees are excluded from eligibility for promotion or to apply for appointment to certain positions simply because they have not been vaccinated. Now, with all of this, and in the context of a workplace, comes the concept of inherent requirements of a job. Do you compel employees to vaccinate because there is no other way or any other means by which they can perform the job other than being vaccinated? Obviously, considering the safety of other employees as well as the public in instances where employees have to interact with the public in performing their duties. Section 6 of the Employment Equity Act prohibits unfair discrimination. Now, we've heard and we know that no right is absolute. In justifiable instances, rights may be limited. Now, some of the recommendations that have come forward are that perhaps when implementing a mandatory vaccination policy is considering making an exemption in relation to employees who have underlying medical conditions which they can substantiate and bring proof of, as well as in relation to employees who are pregnant and breastfeeding. Now, currently, vaccines are not recommended for employees who are either pregnant or breastfeeding, and obviously who also have underlying comorbidities. There's also been recommendation or a view adopted that the exemptions also need to include somebody who justifies and substantiates their objection based on religion or their belief that they should not be vaccinated. So to make their way around, so to say, for employees to make their way around balancing unfair discrimination as it's prohibited by the Employment Equity Act, as well as ensuring business continuity and protecting employees who've been vaccinated, as well as the public. These are some of the recommendations that rather make provision for exemptions, and employees who are refusing to be vaccinated should be afforded a right to explain themselves, so that reasonable accommodation, as it's set out in the direction, can at least be made. Obviously, dismissal has been said to be a measure of last resort. There must be reasonable alternative accommodation. Now, that is all for my presentation. I will hand over to Avinash.
Thank you so much, Peteni, and thanks to you and Fiona for for the, I think, very, very useful insights on important topics. And I think there's going to be further cases that come up that take some of the issues that you've discussed forward, both in respect of the religious, cultural identity issues, as well as the workplace bullying matters. I think it's been appreciated by the audience as well. That's been clear from the comments I've been seeing on the side. I've put a brief synopsis of some of the key insights, starting from Cameron's discussion this morning, so that I don't take further time on that right now. I want to express my appreciation also on behalf of Adil, who's our host, to everyone at CDH that has been involved in putting this event together. We've used a new platform today and must acknowledge that it takes a monumental effort that goes into making such an event a success. The feedback we've enjoyed reading suggests that these efforts have indeed been appreciated by you, our audience. So without mentioning any names, thanks to everyone from the firm, most notably the marketing department, and particularly to the employment law team and all our directors and speakers, as well as our partner from abroad, Bird and Bird, and of course our keynote, Mr. Cameron Morajani, who set the tone this morning. Thank you to all of you for staying the course. Sorry we ran a little bit late. Thanks for your interaction and engagement, which has made the morning an absolute pleasure to facilitate. The discussion and developments will undoubtedly continue, and to kick off that process, please note that the case law booklets that we've produced for the past 8 years will be made available on our website. So that'll be a great bedtime reading for anybody that is that way inclined and who needs to play a bit of catch up on some of the themes discussed today. Watch the space, enjoy the rest of the day. Good afternoon and thank you.